Good morning, everybody.
Good morning, Your Lordship.
Good morning. Yes,
My Lord, may I mention one case from daily cause list, my Lord?
yes.
Serial number 18 and 19.
18 and 19. Yes.
My Lord, in this case, I have circulated an email seeking adjournment, my Lord, on the ground of filing rejoinder, my Lord.
Mhm.
My
So,
Lord,
how much?
3 weeks, my Lord.
2017 matter, you have
My,
not yet rejoined.
my Lord, last week the petitioner came, my Lord, and gave instructions, my Lord. I have to prepare it.
Relevant time हुआ है ना?
It is after there was order of for filing counter. It is coming for the first time, my
Rejoinder has not. Uh, Rejoinder has not yet been filed. Therefore, the counsel for petitioner seeks 3 weeks time. As prayed for, this the matter after 3 weeks, but no further adjournment will be granted.
Obliged, my Lord.
My lords, may I mention one case
May I
of
mention?
may I mention one case of the list, my lords, at serial number 25, my lords. My lords, the state is the appellant in the matter, my lords. My lords, the order under challenge has been passed by the other honorable member, my lords. Honorable Mr. Justice Deepak.
हाँ, earlier order है. अच्छा, एक बार 30 मिनट का ही Let the matter be listed before a bench of which one of us, within bracket Deepak Roshanji, is not a member.
Obliged, my lords.
Your Lordship, may I mention a case?
Yes.
Your Lordship, in serial number 20, I am appearing for the petitioner. Yesterday, we have received the counter affidavit, Your Lordship. I am praying for 3 weeks' time to file rejoinder.
My Lord, in this case, I am appearing on behalf of the respondents, my Lord, railway.
Okay. Yesterday only you have served.
My Lord,
Yes, Your
yesterday
Lordship.
it could be uploaded, my Lord.
Then counsel for the petitioner prays for and is allowed 3 weeks time to file rejoinder to the counter affidavit served yesterday upon her. For the railways, Mr. Rohit Ranjan Sinha.
Obliged, Your
Obliged.
Lordships.
This is recording.
Lordship, may I mention a case, Lordship? Item 27, Lordship. WPT 2478. I have circulated a notice, Lordship, with the consent of parties, Lordship. I was praying for 2 weeks' time in this case. On the last occasion, Lordship has directed to file a counter affidavit to the GST Council, Lordship. We have received the para-wise comments. We are in process of filing, Lordship. We are praying just for 2 weeks' time.
Mr. Amit Kumar, learned counsel for the respondent, prays for 2 weeks time to file counter affidavit on behalf of further 2 weeks time to file counter affidavit on behalf of the respondent GST Council.
Yes, Lordship.
As statements of facts have already been received. So an email was also circulated for that purpose yesterday. As prayed for, matter be listed after 2 weeks.
I pray for the state, my lords, in this case.
Matter be listed after 3 weeks so that petitioner, if so advised, may file rejoinder. There are two in the meantime. For the state, Mr. Salona Mittal. Yes. In item 26, Ms. Amrita Sinha, are you there? और कोई एडजर्नमेंट है? हम्म, 26 में रिटर्न नोट आपने ईमेल से भेजे, मल्टीपल पेजेस का, तो हम लोग को प्रिंट करना पड़ेगा। चलिए कॉल करिए। हाँ, ये अपील के बारे में। अपील हाँ,
तो एक बार शोधना उसके बाद तो ठीक है, जब आप ये तो भरोसा वाली बात हो, इधर नहीं हुआ तो इधर नहीं हुआ।
यस
On the day for it, on the heading of our Mr. Abdul Mr. Commissioner, Mr. Mohammed Mukhtar Khan, for the
how much? 2 weeks. 2 weeks time to Mr. Astos for petitioner to remove the following survival.
My appearance have been noted for the Union of India, Lordship.
You are for?
My appearance for Union of India, Lordship.
So whose name should appear?
Akashdeep AC to Madan Prasad.
Akash
Serial number 1, Lordship.
Akashdeep AC to Madan Prasad for Union of India.
Oblige, Lordship.
item EN number 40 of 2020, along with item number 3, 4, and 5, Mr. Ram number for the appeal.
Manoj, as far as the first item is concerned, Manoj, to my knowledge, Manoj, there was only one defect of filing limitation petition, which we have already filed, Manoj. I'm not sure if there is some further stamp reporting.
Defect number 1, case number may be confined any one of the case number at para 9. Defect number 2, limitation petition may be filed. And 3, court fee paid is short by rupees 230.
Manoj, limitation petition we have already filed, Manoj. That IA is also listed today.
IA. Yes, IA.
It's there. Manoj, the case number also we had done it by way of inspections.
At para 9.
Manoj.
Right. Which is para 9. So the cross appeal had to be struck off.
Manoj, the cross appeal.
Defect number 1 has been removed by striking off the irrelevant part in the aggrieved portion. Now, defect number 2 has been removed by filing limitation petition. What about court fee?
Manoj, court fee I am not very sure, Manoj. If it has not been filed, we'll file, Manoj, within a week's time.
So उसमें ये रिपोर्टिंग भी 19/12/2020 का है.
Manoj, court fees has been filed, Manoj. Court fees has been filed. There is a marking on my file.
When counsel for the petitioner submits that court fees have already been filed. Office to verify. If the defects are, if the court fees has also been filed, matter be listed under appropriate heading. But all of them are tagged.
Manoj. They arise out of common order, Manoj. That is why they have been tagged, Manoj.
अभी नहीं लिखी. बाकी का डिफेक्ट के बाद लिखिए.
Manoj.
Item 3, there is one
Manoj.
court fee short. So that is also a very old stamp reporting. Have you paid that court fee 230?
Manoj, in which item, Manoj? Which serial number?
TA 11.
TA 11, Manoj, I do not have that record, Manoj. Give us 2 days time, Manoj. We'll file the court fees, Manoj, if not filed.
Original copy issue is also here.
My lord, that is already filed in tax appeal 14, my lord. It may be ignored, my lord.
Defect number 1.
Defect number 1 and 2, my lord, they relate to the same issue. That is the original copy.
Defect number 1 relating to filing of original communicated copy of the impugned order with authentication fee is ignored as according to learned counsel for the appellant. The same has been filed in the analogous appeal TA number 14 of 2020 arising out of the common impugned order.
My lord.
When counsel for the appellant undertakes to file deficit court fee of rupees 230 by Friday.
My lord.
Next, item 4 then.
My lord, item 4, my lord, in tax appeal 13, my lord. According to me, my lord, I do not have any defects which is pending according to my records, my lord.
SR defect number 5 still exists. Page number 83 and 84 may be tagged properly. Further, SR defect number 1 still exists, which is mentioned below. Annexure 1 is multi-paginated. That means page.
Defect number 1 was already ignored by my lords on 5th January 2021, my lords. By order dated 5th January 2021, my lords had already ignored that defect.
Defect number 1 was relating to original communicated copy, which we had ignored.
My lords.
Defect number 6 was also ignored.
My lords.
Now, so they are indicating that some annexure 1 is multi-paginated.
Those are internal pages and the running pagination which we do for the memo, my lords. So, my lords, it may be ignored, my lords.
Defects relating to multi-pagination in annexure 1 is ignored as they are internal / running pages. Page number 83 and 84 may be tagged properly. This one,
My lord, we'll remove it. Either office can do it or my lord, we'll remove it, my lord. We'll file inspection and we'll get it.
when counsel for the appellant undertakes to remove the defect relating to tagging of page number 83 and 84 within a week. Item 5.
My lord, item 5, my lord's tax.
Deficit court fee.
My lord, we'll file by tomorrow, my lord. If that is the only defect, my lord.
In 1 week, office to place the file and verify stuff. उसके बाद लिखिए office to verify, and if the defects are removed, the matter be placed, the appeals be placed under appropriate heading for admission.
Much obliged, my lord.
अच्छा, under the appropriate heading, limitation.
Much obliged.
First appeal was 64 of 2021, Mr. Soccer Bigba.
Please, my lord, I'm appearing on behalf of the appellants, my lord. There are certain defects, my lord. There was urgency, that's why we mentioned, my lord. I beg for apology for mentioning the matter. As because, my lord, the present matter was prayed for nullity for the marriage, praying for the marriage for nullity and void, my lord. That petition was rejected, my lord. Subsequently, my lord, we filed appeal. In the meantime, my lord, we got a notice by the trial that the wife is claiming maintenance under section 24 of the Hindu Marriage Act, and the matter is pending, my lord. Tomorrow is the date, my lord. In the present case, my lord, as per the pleadings, the husband has exhibited 2 documents, my lord. The Xerox copy of my lord.
You, first of all, we do not read the files under defective heading, and therefore you should not argue on merits. Secondly, without removing defects, obviously the appeal is not ripe for being argued. So remove it as early as you can. And there are 8 defects. Within 1 week, office to place the file. Defect indicate continue. Mr. Shaukat Iqbal.
Shadab Iqbal, my lord.
Shada requirement. Yes.
Item 7. WPT number 5139 of 2021, Mr. Nitin Kumar Prasad for the petitioner, Mr. Sukumar Yadav for the report.
Minutes, the defect as has been pointed out is with regard to annexure 2. Minutes at page
Certified
80.
original check 2 with a authentication fee may be given. Yes.
Now, minutes, if pilots would see annexure 2, it's a letter issued by the Joint Commissioner.
Check 2 is a letter. Defect number 1 is ignored as annexure 2 is a letter issued by the Joint Commissioner of State Tax Admin Ranchi Division. Stuff. Matter be listed under. What is this matter about?
Minutes is the same matter Milots had heard earlier, refund of online shopping. If Milots would remember, WS Retail.
Okay. So we have perhaps remanded the matter in that matter.
So Milots, one matter Milots had remanded, we have been granted refund. Now this is for Ranchi division and Jamshedpur division, where the same issue has cropped up. That was pertaining to Dhanbad division. So Dhanbad division has granted refund.
Mr. Gulati
Yes,
was perhaps in that.
Yes. Mr. Tarun Gulati had appeared on that matter. So let both these matters come up on the same day next week, Milots.
No, what about the 3 defects in the next matter? 3, 6 and
Milots,
8.
only one defect survives, that is defect number 6. That is again the same thing, annexure 2.
3, 6 and 8.
Milots, 3 and 8 we have removed, Milots.
Prayer made in prayer portion is different with the prayer made in para 1. Then defect number 6, certified original copy of annexure 2, of course that is ignorable. Defect number 8, typed copy of page number 120.
Milots, so far as defect number 3 and 8 is concerned, we have already removed it, but Milots, I'll check it, I'll verify it. Milots, so both these matters can come up in the next week, Milots. If the defects are there with regard to serial number 3 and 8, we'll remove it by tomorrow.
Then counsel for the petitioner undertakes to remove the surviving defect number 3 and 8 by Saturday.
Yes, Milots.
Office to place the file for inspection on requisition being made. Defect number 6 is ignored as annexure 2 is a letter.
It's an internal Milots document, Milots.
Which annexure 2, that page?
Milots 75. I have given the type copy, Milots. It's an internal noting.
Annexure 2 is an internal noting as per the counsel for the petitioner.
Yes,
Stop.
Milots.
Defects, let in this case be tagged along with WPT 5139 of 2021, also on board today. Stop. If the defects are removed, the matter will be listed.
Milots, next week, Thursday.
Mr. Mittal, you are appearing in both them.
Yes, Malaj. I am appearing, Malaj. As far as the matter relating to Jamshedpur division is concerned, Malaj, 5188, I currently do not have instructions, but Malaj, as far as the Ranchi division matter is concerned, 5139, Malaj, the department has prepared an SOF. Malaj, if it is getting remanded, then I do not see why a counter may be necessary. So, Malaj, it may come up next week. Malaj, there is an additional point that they've taken, that the petitioner itself is the consignee in the state of Jharkhand, and therefore it will be an intra-state sale. But Malaj, all of that can be looked at the time of remand. So Malaj, it may come up next week, Malaj, and if it is being remanded, a counter may not be necessary.
If the defects are removed, the matter be listed in the next week.
Much obliged,
Milots. Next, our order.
Yes, I have annexed.
And the
Yes.
Dhanbad order
Yes, Manoj, I have annexed it.
Very well. Tag कर दिए थे ना. हाँ. ये वाला है कुछ. Flipkart वगैरह.
Progress. Item 9, first appeal number 42 of 2020. Mr. Jitendra Tupadhyay for the appeal. Mr. Gul Kasturbai for the response.
My lord, in this case, I am appearing on behalf of respondent, my lord.
Yes, Lord, I am appearing for the appellant.
794 days.
Yes, my lord.
My lord, in this case, I want to reply, my lord, for IA, my lord.
You reply, but husband was asking divorce under Special Marriage Act. The marriage was registered under Special Marriage Act.
Yes, my lord.
Yes, ma'am.
Then it is maintained. And counsel for the respondent, Mr. Jitendra Nath Upadhyay. नहीं, कौन है?
नहीं, I am appellant, my lord. Tarun Kumar, my lord.
I am for the respondent, my lord.
Arun Kumar Mahto is praised for is allowed 2 weeks time to file reply to the IA seeking confirmation of delay.
Obliged, my lord.
District after 2 weeks. Good. कैबिनेट मीटिंग के हर वीक में प्रेशर लास्ट में लगने लगता है किसी तरह. Yes.
Item 8, LP number 54 of 2020. Mr. Rakesh Kumar.
Lord, in this case, my lord, in IA application has been filed for continuation of delay in filing the instant appeal. There is, my lord, delay of 154 days. That is in filing the.
For another bench. Let the matter be placed before a bench of which one of us within bracket Aparesh Kumar Singh is not a member. Another thing again for him. Your fractured leg is okay now.
Now I'm sitting now with a leg, with this stick.
Okay.
But I can move, my lord. I can move.
Very well. Nice to see you in.
Thank you, sir.
Good,
Thank you.
good positive mood.
Thank you.
Yes. Next.
Item 11, first appeal number 65 of 2020. Mr. Abhishek Kumar Dubey for the appeal.
May it please your lordships. In this case, your lordship, one defect was pointed out by the registry that there is a delay of 181 days in preferring the present memo of appeal. I have filed an IA for ignoring the defect, as my submission is that there is no appeal. There are two decisions. One passed by your lordships in FA number 49 of 2019, wherein it has been held that the period of limitation for filing a appeal under section 19 of the Family Courts Act will be 90 days and not 30 days. And secondly, that Honorable Supreme Court in the case of in suo motu writ petition 3 of 2020 has already held that period of limitation from 15/3/2020 till 15/2/2022 shall be excluded from while calculating the period of limitation. So in this case, there is no limitation as such.
IA number 6172 of 21 has been filed by the appellant for ignoring the defect relating to filing of limitation petition. And counsel for the appellant has referred to the judgment name order dated 16 December 2020 passed in FA number 49 of 2019 by this court, holding that the period for limitation for preferring an appeal under section 19 of the Family Courts Act against a judgment and decree passed under the Hindu Marriage Act. That you have not mentioned in your para. Under the Hindu Marriage Act, shall be 90 days and not 30 days. 90 days in terms of section 28(4) of the Hindu Marriage Act.
19(4) of the
19(4) में 30 days है भाई 19 में.
28(4) of the Hindu Marriage Act.
28(4) of the Hindu Marriage Act.
Hindu Marriage.
Stop. Order is enclosed. Land Council for the appellant further relies upon the order passed by the Apex Court in suo motu writ petition civil number 3 of 2020 dated 23rd March 2020 and also the order dated 23rd September 2021 passed in re cognizance for extension of limitation by the Apex Court and submits that
In page number 29, it has been. Paragraph 8.
that the period from 15th March 2020 till 2nd October 2021 shall stand excluded for the purposes of computing limitation for any suit, filing any suit, appeal, application or proceeding. So the balance period remaining as on 15th March 2021 shall be available with effect from 3rd October 2021. It is submitted that the appeal, the impugned judgment is dated 2nd January 2020 and the limitation ordinarily would have expired after 90 days. The appeal was filed on 21st August 2020 during the lockdown period. Or neither was it beyond time when the lockdown started, nor is the delay thereafter, nor is there any delay thereafter in view of the order passed by the Apex Court. Accordingly, the said defect is ignored. On consideration, the said defect is ignored. IA stands disposed of. Issue notice on the respondent under registered cover with AD, speed post and ordinary process. Speed post and ordinary process for which requisites be filed within 1 week. Entry.
Obliged.
Item 12. File copy number 68 of 2020, Mr. Niranjan Singh from the appellant.
Order admission. Issue notice. For admission. Issue notice on the respondent under the registered cover with AT and speed post for which requisites be filed within 2 weeks. Anyone appearing for the appellant? Entry करते हैं इसमें नहीं होता 2 weeks. Next week से physical Next.
Item 30. File copy number 88 of 2020, Mr. Sasikant Thakur for the appellant, Mr. Jamil Sultan for the respondent.
Lordship, I am acting on behalf of the appellant, Lordship. Lordship, I have for condonation of delay about 509 days, Lordship.
Mr. Haq, you are appearing for the respondent.
I am appearing for the respondent, my lord.
Any objection to the delay condonation application?
No objection, my lord.
Third learned counsel for the parties on the prayer for condonation of delay of 509 9 days on preferring the instant memo of appeal made through I number 3464 of 21. Then counsel for the appellant submits that appellant residing in remote area in West Bengal could not collect information within time for preferring this appeal. Stop. She was also suffering from illness. Stop. The delay is not intentional. And petitioner appellant also was facing financial crisis. Appellant was also facing financial crisis. Stop. The delay is therefore not intentional. It may be condoned since divorce has been granted in favor of the respondent wife. Acha. Restitution has been granted in favor of the respondent wife by the impugned judgment dated 3rd July 2019, passed by Learned Family Court, Pakur. Document counsel for the respondent does not have any serious objection. On consideration of the ground served and the submission of the parties, delay is condoned in the interest of justice, since the dispute is a matrimonial one also. Also a matrimonial one. Stop. Go for mediation.
लॉर्डशिप पाकुड़ भेज दिए लॉर्डशिप।
फिर पाकुड़ में तो कोई फायदा नहीं होगा, वहां पर तो आप लोग दोनों लड़ ही चुके हैं। झालसा में अटेंड करिए, थोड़ा मेहनत करके आइए।
झालसा ठीक रहेगा मैन, झालसा ठीक रहेगा। यस
ठीक है, तो फिर हस्बैंड विल हैव टू पे, बीरभूम से आना है इनको
लॉर्डशिप।
बीरभूम से तो फिर नहीं लेडी तो पाकुड़ से आएंगे। अच्छा
नहीं लॉर्डशिप, ये बीरभूम से आना है लॉर्डशिप। एट प्रेजेंट रिजाइडिंग एट बीरभूम लॉर्डशिप, वेस्ट बंगाल लॉर्डशिप।
एपेलेंट का बात नहीं कर रहे हैं, वाइफ को।
एपेलेंट की वाइफ है लॉर्डशिप।
तो दोनों का नाम
लॉर्डशिप, ये सखी कुनाई लॉर्डशिप वाइफ है लॉर्डशिप।
अच्छा वाइफ
लॉर्डशिप।
Then counsel for the parties agree that an effort for amicable settlement of the matrimonial dispute between the parties should be explored through mediation at Jhalsa. Since the marriage is only, this is the marriage was performed in 2015 and not, कोई बच्चे भी हैं?
नहीं लॉर्डशिप, कोई बच्चे नहीं।
Oh, and there are no issues out of the. Stop. They are ready to appear physically at Jhalsa. Stop. In that view of the matter, let the parties appear before the member secretary Jhalsa on 26th February 2022 at 10:30 a.m. Stop. And member secretary can also be approached.
लॉर्डशिप थोड़ा सा टाइम दे दीजिए लंबा लॉर्डशिप, मार्च का कोई डेट लगा दीजिए, फर्स्ट वीक की लॉर्डशिप।
नहीं ये
आफ्टर होली माय लॉर्ड,
नहीं
आफ्टर होली माय लॉर्ड।
आप लोग अपने कन्वीनियंस से क्यों डेट बोल रहे हैं? पार्टीज को आना है, जिस दिन कोर्ट ऑर्डर करेगी उस दिन आना पड़ेगा।
एक्चुअली माय पिटिशनर वर्किंग इन अदर स्टेट, सो काइंडली 1 month मोर देन
1 month से बस ही डिफीट हो जाएगा। मीडिएशन ज्वाइन करने के लिए 1 month, उतना दिन में तो कई डेट हो जाएगा। सैटरडे को इसीलिए रख रहे हैं कि सैटरडे संडे 2 दिन लगातार मीडिएशन हो जा सकता है। हाँ, ज्यादा से ज्यादा 26 के बदले में 5-6 मार्च को कर देते हैं।
ओके,
5th of March. So, on their appearance, matter be placed before the learned mediator Jhalsa for undertaking the exercise. Since the parties have to come, since the appellant a wife has to come from Pakur, the respondent husband shall pay a sum of rupees 1,500 on each date she attends the mediation proceedings, in the presence of learned mediator Jhalsa towards travelling and incidental expenses. When the parties are coming far off places, then a mediator would never put the sittings on consecutive days. And subsequent dates may also be given as per the convenience of the parties. Parties are expected to cooperate in the proceedings and attending to the sittings. If they are able to arrive at an amicable settlement, terms and conditions thereof be reduced in writing under the joint signature and be submitted along with the report 4 weeks thereafter. The matter will be listed in the week of 18th April 2022.
So 116, sorry, my lord, item number 12, my lord. But it's my prayer on behalf of the learned counsel, Mr. Niranjan Singh, my lord. But it's a marriage is going to be held today in his house at Dhanbad, my lord. And since adjournment may kindly, my lord. Item 12, my lord.
We have item 12, we have issued notice under speed post and registered cover. And 2 weeks' time has been given to file requisites.
Yes, obliged, yes, obliged, yes.
2000 कर दीजिए 2000 दिन दीजिएगा भाई ये कॉस्ट मींस पाकुड़ इज एट फार डिस्टेंस 2000 कर दीजिए
Online.
यस नेक्स्ट
Item 14. Mr. Mahesh Kumari for the applicant, Mr. Pandit Neeraj for the.
In this case, Your Lordship, I was only praying that it may be allowed to be withdrawn, Your Lordship. And today we have filed an IA application for withdrawal. Posted in the box.
Sir, please ensure that a copy is mailed to me also. Tiwari, sir.
Learned counsel for the appellant Mr. Mahesh Tiwari seeks permission to withdraw this appeal on instructions. Stop. An interlocutory application has also been filed today.
Yes, Your Lordship, in the drop box.
In the drop box. Stop. Learned counsel for the respondent husband, Mr. Pandit Neeraj, does not object to the prayer. Accordingly, the instant appeal is dismissed as withdrawn.
My lord, I am only respondent's counsel, my lord, I am not husband.
Learned counsel for the respondent.
No, my lord, that's all right, my lord, but the language, my lord, will give an impression that I am learned counsel for the respondent and also husband. On the lighter note, my lord.
IA number so and so stands closed.
Much obliged, my lord.
Yes. This time you did not get infected, Mr. Neeraj?
I did, my lord.
As a third time again.
Yes, my lord.
Oh, you are making a record of sorts.
My lord, it comes to change its mood to me, my lord, and we talk and we joke with each other, and it doesn't.
No, you should be an ideal lab, what you call, specimen, lab testing.
No, but my lord will appreciate. God has been so kind. In the second wave, I did not contract, which was very dangerous. My first two rounds were in the first wave itself. God has been really kind, my lord, that way. Twice in the first round made me, my lord, strong enough to avoid it in the second round, which was dangerous.
No, these examples should actually be tested by the virology labs as to how you are getting infected also and how your antibodies are developing and what is the kind of immunity which is generated.
Actually, my lord.
Sure, you must have been vaccinated also.
Yes. But my lord, vaccination doesn't prevent contraction.
And that's true.
It only
Serious.
helps. It must have helped me.
Okay. Mr. Tiwari, you mail the copy of the IA to the court master so that it can be kept on record. And
Yes,
give
Your
a
Lordship.
copy to Mr. Neeraj Roy also.
Yes, Your Lordship.
Yes.
Item 20, first appeal number 30 of 2021, Mr. Mukesh Kumar for the appellant, Mr. Shankar Singh for the recommend.
I am appealing on behalf of the respondent, my lordship. My lordship, the first appeal number 13/2021 become infructuous, my lordship, is because my lordship respondent has solemnized second marriage, my lordship, on 13th June 2021, and thereafter the same marriage was registered on 2nd July 2021, my lordship. Thereafter, the illegal and void and ab initio. My lordship, my submission is that this IA application is not maintainable, my lordship, is because court has no jurisdiction to pass any order, is because my lordship pass a suitable order in this case.
I am, no, I am along with Mr. Lokesh Kumar in this matter.
Okay.
I don't think the appeal has become infructuous. There are two dates which your lordship will make note.
Appeal may not become infructuous, but the prayer for seeking an annulment in this present appeal may not be maintainable. You can file a suit.
That my lords, my submission is that if I succeed in the appeal, automatically it will be deemed to be void as per the judgment of Supreme Court. I do not go to a court to get a declaration because it has been performed, solemnized in contravention of law. It will not be recognized in law. So to that extent,
Send that judgment, the latest judgment.
I have seen that latest judgment. That judgment is on a different facts altogether, my lords. Now here it's a question where the marriage is admitted after passing of a decree of divorce and before expiry of the time to prefer an appeal, and I preferred the appeal within time. He solemnizes a second marriage. That's anyways a void marriage, my lords. And that is what 2002, my lord, Savitri Pandey has said, my lords.
No, so then send those judgments to us, which you will like.
What I was proposing, my lords, what I was proposing is, so your lordship may consider this IA along with the time of final hearing and fix this case at an early date so that this issue is resolved because the life of three people are involved. So whether I have to get divorced, not get divorced, whether the appellant will get divorced, not get divorced, whether the marriage will remain, not remain. But if your lordship may be kind enough to hear it on an early date subject to your lordship's convenience, I think that will take care of it.
So there was no delay in preferring the appeal.
No, that's what I'm saying. The delay, if at all, also was not there. The judgment was passed on 26th of March. I never got the decree. I preferred the appeal on 11th of June itself. That is within 3 months in view of your lordship's order in Prerna.
But my lordship, decree has been challenged after the filing of the judgment, my lordship.
So no one can take advantage, my lords, of the delay in the procedure. I have preferred an appeal with the judgment on 11th of June.
Office has not pointed out any delay.
No, it has not. So my appeal is within time. Only the decree was missing, which got prepared only later onwards. Now I can prefer an appeal with the judgment. There is no mandate that I must prefer an appeal with the decree.
But my lordship, both are maybe challenged, my lordship.
The respondent, despite even if I would not have preferred. The law is you must await the expiry of the limitation period to get a second marriage. He did not even wait for he just didn't even check that an appeal has been filed. Got married immediately after 3 days of the expiry of the limitation period, without even checking that an appeal has been filed.
Lower court records have already been called earlier.
My lord.
Yes, my lordship.
Yes.
There shall be stay on the impugned judgment also.
That your lordships have said.
Admit. Lower court records have already been received. Stop. Then counsel for the appellant, Mr. Indrajit Sinha, submits that prayer made in IA number 2728 of 21 has become infructuous as the impugned judgment has already been stayed. Dated 26 March 2021 has already been stayed by order 8 July 2021. Stop. He submits that IA number 5756 of 2021 seeking amendment in the memo of appeal and with a prayer for amendment in the memo of appeal to the extent that the second marriage performed by the respondent after filing of this appeal on what is the date?
On 13th June 2021.
The appeal was filed on 11th of June 2021. Marriage was solemnized on 30th of June 2021.
No,
After
appeal
96 days, my lord.
14th June.
Okay. Yes. We registered. We must have filed it, but registered on 14th of June. Very well.
So marriage is of which date?
30th of June.
Okay. No dispute about it, Mr. Shankar Singh, about the date
Yes,
of
my
marriage?
lord, no dispute.
30th June 2021. With a prayer for declaration of the second marriage of the appellant performed on 30th June 2021 after filing of the appeal on 14 June 2021 as null and void. Stop. ये पूरा सेंटेंस क्या लिखे
amendment in the memo to the extent that second marriage performed by the respondent after filing of the appeal on 30 on 14 June
ऐसे फिर से लिखे. Then counsel for the appellant submits that IA number 5756 of 21 seeks an amendment in the memo of appeal for a declaration of the second marriage of the respondent solemnized on 30th June 2021 after filing of the present appeal on 14 June 2021 as null and void. Stop. The same may be considered at the time of hearing. Stop. Let the matter be listed under the heading for hearing. In the month of August 2022.
Very good.
Many changes in the society.
Yes.
For admission, item 16, WPT number 1579 of 2017, Mr. Sanjay Purwas, for this matter.
My lord, Mr. Sudhir Sahai will argue, your lordship. My senior.
Yes. Unmute yourself, Mr. Sahai.
Kindly unmute your line.
Motor Vehicles Act approves Ravi. Pass over.
Item 70, WPS number 6118 of 2017. Mr. 8 month of the Rahul
Yes. Yes, Mr. Khan. Mr. Khan, unmute yourself. आवाज नहीं आ रही है आपकी मिस्टर खान, अनम्यूट करिए.
Are you hearing, my lord?
Yes, we are able to.
Before arguing, I am appearing on behalf of the petitioner, my lord. Before arguing my case, I want to inform you this court that petitioner has already been retired in the month of December 2021 without redressing his grievance, my lord. The instant petition is filed against setting aside the order dated 7/2017 passed by the CAT Ranchi bench, my lord, where the promotion has been denied as income tax to the petitioner, my lord. इसमें ये लोग बोलते हैं हुजूर 21/12/2004 का जो नोटिफिकेशन था हुजूर उसमें लोग अमेंड कर दिए हैं. अब बोलते हैं उस हिसाब से इनको प्रमोशन नहीं दिया जाएगा. बट दिस पिटिशनर इज एलिजिबल फॉर द प्रमोशन एज पर द 21/12/2004 because my lord, because under requirement rule 1994 and 2004 he completed 3 years of regular service without any blemish, my lord. और इसमें सीएटी my lord मेन जो केस जो डिसाइड किए हैं जो लिमिटेशन पीरियड में डिसाइड कर दिए हैं, लिमिटेशन पीरियड को ही फोकस करके बोलते हैं कि ये जो नोटिफिकेशन था 21/12/2004 का इस पे मॉडिफिकेशन कर दिया गया हुजूर विदाउट एनी वैलिड रीजन एंड पिटिशनर हैज बीन डिप्रीव ऑफ फ्रॉम द डीपीसी ऑफ 2004 टू 2004 से 2005 तक हुजूर कोई डीपीसी इसमें नहीं कंडक्ट हुआ. अब इसी के चलते हुजूर हम एग्जाम में नहीं बैठ सके हुजूर. मेन कॉज मेरा यही है. आई हैव बीन डिप्रीव ऑफ.
2013 में आपने ओए फाइल किया आफ्टर सच ए लॉन्ग डिले.
जी हुजूर हम उसमें एमए भी फाइल किए थे हुजूर, लेकिन एमए को हाफ पार्शियली मानते हुए हुजूर एकदम मैकेनिकल ऑर्डर पास कर दिए हैं हुजूर. मेन उसी को बेस बना लिए हैं कि आपका बार्ड है लिमिटेशन.
एमए भी 3 साल बाद फाइल किए.
जी मालूम इसमें तो हम रीजन दिए थे.
नहीं, इसमें कोई मेरिट खास नहीं है. Third learned counsel for the petitioner, Mr. Muhammad Anisur Zama Khan and Mr. Prashant Vidyarthi appearing on
Union of India.
Union of India. Stop. By the impugned order dated 17th February 2017, Next 13, the learned Central Administrative Tribunal Circuit Bench Ranchi has dismissed OA number 051/00164/2013 with MA number 051/0008/2017. The applicant petitioner being aggrieved therefrom has preferred this appeal. The original application was preferred with a prayer. with a prayer. To direct the respondents to promote the applicant to the post of income tax officer in view of the notification dated 21st December 2004 by giving weightage to his seniority with all consequential benefits from the date of eligibility. Stop. The original application was preferred in the year 2013 and the cause of action raised by the petitioner related to the year 2004. Stop. For condonation of delay, MA number 08 of 2017 was filed after 3 years of filing of the original application, taking grounds of illness of his father from 2000 onwards and later his son's illness. Stop. Petitioner did not make any averment to show that any person junior to him has been promoted under the Recruitment Rules 1994 and the notification dated, read with the notification dated 21st December 2004. Through promotion. The learned tribunal found the pleadings completely vague. Stop. Respondents had contested the case by filing a written statement. Taking a stand that due to change in the rules position between position 2003 to 2005. The rules, the Income Tax Officer Group B Recruitment Rules 1994 provided a condition for eligibility for departmental examination, which were amended in 2004. Stop. There was no such provision for deleting the condition for holding departmental exam.
Just page 48 of the petition, my lord. Our written statement is there, my lord.
Right, I'm reading that.
Yes.
Petitioner cannot claim an indefeasible right for being promoted. Later, by notification dated 24th March 2005, the President of India promulgated the Income Tax Office Income Tax Officer Group B Post Recruitment Rule 2004. The Income Tax Officer Group B Post Recruitment within bracket Amendment Rules 2005 in exercise of the powers under Article 309 Proviso. It provided that for promotion, the inspectors of income tax in the scale of rupees 6,500 to 10,500 with 3 years regular service in the grade and who have qualified the departmental examination for income tax officer were eligible for consideration. Petitioner, however, approached the court, learned tribunal, after 9 years for the instant relief with vague pleadings and no foundational facts relating to promotion granted to any junior. The learned tribunal considered the case of the parties on the basis of pleadings and on record and dismissed it as hopelessly barred by limitation and also without any merit. Stop. Then counsel for the petitioner submits that the OA has been dismissed both on grounds of delay, but the learned tribunal also opined on the merits of the case without proper consideration of the case of the applicant. Stop. We have considered the submission, therefore it needs interference. Petitioner has retired in December 2021 from service. Stop. We have considered the submission of learned counsel for the parties, taken note of the materials relied upon from the lower court, from the reports. Stop. The dismissal of the OA on pure grounds of delay do not appear to be suffering from any perversity for this court to take a substitute view in exercise of Article 226 of the Constitution of India. Stop. A perusal of the impugned order and the pleading order also shows that petitioner has not shown that any person junior to him was granted promotion, ignoring his claim and thereby caused discrimination. Stop. The OA was filed after 9 years of the alleged cause of action, and the delay condonation application was also preferred 3 years thereafter. Stop. The learned tribunal looked into the merits of the case also, but in the absence of any but in absence of any specific averment with proper and complete foundational facts, also held that the pleadings are vague. Stop. Learned counsel for the petitioner has not been able to improve his case beyond that. at this stage also. Stop. We therefore do not find any infirmity in the impugned order calling for interference. The writ petition is accordingly dismissed.
Manoj, I was only praying, Manoj, my name for respondent income tax department may be recorded, Manoj.
Lordship, in para 19, I have stated that a Madhya Pass candidate qualified one exam for ministerial revenue and reaches to the rank of gazetted officer. I am the direct appointee, my lord. Like petitioner may be promoted to the post of income tax officer by considering the notification 21/12/2000। मध्य पास के लोग भी हुजूर बहुत ऊंचे रैंक में चल गए हैं, हम तो डायरेक्ट अपॉइंटेड थे हुजूर।
दोनों फिर तो डिफरेंट क्लास के हो गए ना। आपके क्लास में कोई आपसे जूनियर प्रमोट हुए हैं तो उनका एग्जाम्पल देना चाहिए था आपको।
I have stated in para 19, my lord.
डिपार्टमेंटल एग्जाम आप कोई क्वालिफाई किए ही नहीं।
जो डिपार्टमेंटल एग्जाम तो हुआ ही नहीं हुजूर, 2003 से 2005 तक हुजूर। ये तो हमको डिग्री कॉप कर दिए, एग्जाम तो ये लोग लिए ही नहीं। 2003, 2006 और 2005 में हुजूर कोई डिपार्टमेंटल एग्जाम कंडक्ट हुआ ही नहीं हुजूर। Due to the non-holding of the examination, I could not appear in the departmental examination. This is not fault from my side, my lord.
True, but then the applicant as a class did not get a chance to face any departmental exam during that period, and that was because of the fluid rule position that the respondents are admitting. Unless and until you show that during that period or thereafter some junior has been promoted without holding a departmental exam, then you could have made a case.
Manoj, my appearance, Manoj, sir. If Manoj, much obliged.
Good. 17.
Article case for admission, item 16, WPT number 1579 of 2017. Mr. Sanjay.
Next. Mr. Sudhir sir.
Sudhir sir.
Item 21.
Mr. Piprwal, Mr. Sahai is not able to join.
My lord, I am requesting him, your lordship. Just now, I am requesting your lordship. Just now.
We are calling, the court master is calling.
My lord, he has some technical difficulty, your lordship. I am just calling your lordship, requesting him, your lordship.
I have been sitting with him to help him.
My lord, in fact, he is conducting from his chamber, your lordship, and I am in my chamber. My lord, just now I am requesting your lordship.
You are asking the court to wait for the counsel. उसके बाद का केस कॉल करिए.
Item 20, WPT number 1434 of 2020. Mr. Sumit Garudia for the police man. Mr. Rajesh Iyer, Mr. Ramesh Kumar for
Lordship, in 21 we have given NOC and in 22 we are appearing, my lord. Probably in 21 Ms. Amrita Sinha is appearing now.
Your Lordship, in 21 I am there, Your Lordship.
21 now you are appearing.
Yes, Your Lordship. Yes, Your Lordship. In this case, Your Lordship, although I have not sent the judgments upon which I will be relying upon, I got late in that, Your Lordship, but the matter relates to filing of the allowing to rectify a TRAN 1 within the specified period. There was a provision, specific provision under the GST Act wherein it was allowed to rectify the mistake once in TRAN 1, if any, that is section 120A. However, due to technical problem, I was not allowed to, and even my complaint has yet not been registered itself also, Your Lordship, in spite of representation given in this behalf. The rejoinder and all are filed, Your Lordship, but certain judgments I could not send, Your Lordship. So if it can be posted for next week, Your Lordship, then it can be finally heard on that day.
Lord, I have only in the next case I am appearing, my Lord. It's also TRAN 1. Only one thing I have to submit, my Lord. There are some set of judgments which permitted, my Lord, submission of TRAN 1. The revenue has gone in appeal, and in all the appeals, my Lord, there is an interim order of stay and the contempt proceedings have been stayed. I have submitted the compilation, my Lord, in my case. I have sent it through email yesterday.
In brand equity, there are 3-4 judgments.
Brand equity is stayed by the Honorable Supreme Court.
Yes, there are certain judgments also, Your Lordship, wherein the Honorable Supreme Court has dismissed the SLP filed by the Revenue Department and have allowed and have upheld the order of the High. There are those judgments. One of the judgment is already annexed with my writ petition, Your Lordship, and the other one is Union of India versus India Retail. Recent judgment, it is, Your Lordship, wherein the order of the Honorable High Court has been upheld by the Honorable Supreme Court, Your Lordship, wherein it has been electronically allowed to file either TRAN 1 or modify the TRAN 1 within either manually or by opening the electronic portal. So far as brand equity is concerned, there was certain general direction given therein, and for that purpose, the matter stay has been given in that case, Your Lordship. A general direction, a very vague and general direction was given in that particular matter, Your Lordship, that for all of the taxpayers, even though who are not the petitioner before the Honorable Court.
Ban equity case, Lordship, the limitation has been extended for 3 years by the Delhi High Court, which has been stayed by in SLP by the Honorable Supreme Court.
Altogether, 9 appeals that we have stated in the counter bid. Altogether, 9 SLPs.
I have not received any such.
No, I have sent it to Mr. Gorodia. I was not aware.
Okay.
My Lord, may I just indicate in the second matter, Mr. Pati is appearing. So, my Lord, there was earlier direction for filing counter affidavit. If they don't intend to file, I have no objection to that.
I have filed it. It has not reached you.
No, but CGST, we have received.
I'm for CGST. GSTN in second case, not for the state.
Second no file, sir.
I am not aware whether the state has filed or not.
Item 21, Ms. Sinha, you have sent some judgments through mail yesterday, or item 22 you have sent judgment?
No, Your Lordship, for item number, I have not sent any mail yesterday. So for 26 also I am appearing. In that regard, I have sent certain mails. But for so far as 21 is concerned, I could not send, Your Lordship. So for that reason only, I was just asking for 1 week so that I can send the compilation, the complete compilation in that matter, and it can be finally heard on that day. I will be also submitting a short list of dates.
In 22, I have sent through email, my Lord, the compilation of the Honorable Supreme Court judgment and 3 High Court judgments.
So that compilation is of 94 pages. How many pages will we print out?
My Lord, I will submit the printouts, my Lord. Yesterday it was late in the night. So from next week, my Lord, we will submit the physical volumes and court is to resume physically. That will be done. I will supply today itself, my Lord.
My Lord, may I indicate in item 22, my Lord, there is a short IA also. It's a formal IA, my Lord. The document was already annexed. So that may be allowed to be challenged by way of abundant caution. IA number 4
should come together on any day because they are raising same issue.
I think the first matter is a little different. Second matter is, of course, it may come on the same day. And my Lord, I will also send all the judgments. My Lord, will assist your Lordships, my Lord, as a officer of the court, my Lord, Mr. Pati has also sent. There are rival judgments, my Lord, from both sides in the matter.
Yes.
Item 21 relates to availing of transitional SEMVAT credit.
Yes, Your Lordship, the filing of the rectified TRAN 1, for filing of the rectified TRAN 1.
And item 22 relates to availing that VAT.
No, my lord. Item 22 is the original Tran 1 itself could not be filed.
Okay.
And in item 21, original Tran 1 was filed. But there was
Yes.
some error and there was some rectification sought which was not permitted.
And that was
This
not
is the
allowed.
only difference.
Tran 1 was filed with respect to the spare parts, not with respect to the stock in.
Sir, in that
Incorrect,
we
it
have
was filed,
already
sir.
filed that Tran 3, Your Lordship, but due to a new law was there and lot many confusion were there, and for that reason only we were under impression that Tran 3 is sufficient. It was informed that Tran 3 is not sufficient declaration, we have to file in Tran 1, and for that purpose we want to rectify our Tran 1 in that particular thing.
इसमें देखिए तो इसमें आ रहा है
So in item 21, Mr. Pati, you are there or Mr. Amit Kumar is there?
Mr. Amit Kumar in item 21, my lord, and item 22, myself, my lord, for CGS.
Very well. So next week it won't be possible, but in the week thereafter or in the week of 7th March, we can put these two matters.
Let it be after Holi, my lord. This matter will give all the compilation subject to your lordship's pleasure.
We don't have any difficulty. 22nd March.
The second, yes, Your Lordship.
So item 21 may be likhiye, as prayed for by learned counsel for the parties. This is the case on 22nd March 2022. Learned counsel for the parties would supply a compilation of decisions and provisions on which they seek to rely at least 1 week before the next date of hearing through the court master. In item 22, Mr. Pati, your CGST counter affidavit is already there.
Yes, my lord.
I'll take it from Mr. Pati. It is not in my records.
Yes,
I'll take it from him, my lord. There's a small IE, my lord, formal IE.
I have filed a reply to the IA also.
Yes, my lord. I will serve both to Mr. Garodia, then maybe on the next day only.
The reply to the IA is not with you, Mr. Garodia.
I think no number of the reply has reached you. Maybe due to some reason we have served it, it may be not with him.
Take it up on the same day on 22nd.
Yes, it is very formal, my lord. So the IA is very formal.
As prayed for by legal counsel for the parties, this is the case on 22nd March 2020.
Obliged, my lord.
Much obliged.
Obliged, my lord. अरे इसका चेक करो तो
Mr. Pati, yourself.
Mr. Pati.
My lord.
Mute yourself. You were being.
My lord, I'm sorry. But this, I'll restart the computer. There is some error and problem in this.
Mr. Ajay Kumar sir, for the appellant. Mr. Ajay Kumar for the appellant.
May I please, Your Lordship? I am appearing for the appellant, husband, Your Lordship.
Let it be admitted now mediation has failed.
My Lord.
Mediation has failed as per the report of learned mediator Jhalsa, bearing letter number so-and-so, dated so-and-so. Admit call for lower court records in connection with so-and-so from the court of so-and-so. Place the matter under the hearing for hearing on receipt of LCR as per its age.
Much obliged.
Item 24, first appeal number 12 of 2021. Mr. Salendraji for the appellant. Mr.
My lord, I am appearing on behalf of opposite party, my lord. Mr. Sumit, alleged consultant Sumit, that his mother died before 1 hour, my lord. So he is not able to assist the court.
So both of you go for mediation.
Yes, my lord. I am appearing on behalf of appellant, my lord.
Marriage is of 2012. Who was appearing? Mr. Abhishek.
Yes, my lord. Yes, my lord.
Mr. Abhishek, come on the screen. The respondent on notice through Wakalatnama. Mute yourself. Your audio is causing disturbance. And come on the screen also. Learned counsel for both the parties agree that an effort for amicable settlement of the matrimonial dispute can be explored through mediation at this appellate stage also. Stop. Parties are willing to attend mediation physically at Jalsa. Stop. Accordingly, let the parties appear before the 11-member Secretary Jalsa on 26th February 2022 at 10:30 a.m. Stop. And member Secretary Jalsa can also be approached on the following numbers. Stop. On their appearance, matter will be placed before the mediator Jalsa for undertaking the exercise. The parties are supposed to cooperate with an open mind and attend each of the sittings. Appellant shall pay a sum of rupees 1,250 to the respondent on each date she attends the mediation, in presence of learned mediator Jalsa. Stop. If the parties are able to arrive at an amicable settlement, terms and conditions thereof be reduced in writing under their joint signature and be submitted along with the report 4 weeks thereafter. This is the case in the week of 11th April 2022 along with the report. Mr. Abhishek Chandra, you tell your client to appear on 26th.
Okay, my lord. Online.
At Jalsa, 26th February.
It may be next week, my lord, 25th of next month, my lord.
No.
Because, okay, online.
Yes.
Item 26, WPT number 786, subsequent 21, Ms. Amrita Sinha or the petitioner, Mr. PSC or the respondent.
Yes, Your Lordship, in this.
In this one also you have sent an email yesterday.
No, Your Lordship, earlier it was when listed on that day I sent the entire judgment, that is on 16/2/2022 I have sent the judgment upon which I will be relying upon in this case. इसमें कल भेजे हैं ना mail? Yesterday itself I have sent the mail. I'm so sorry, Your Lordship. Yesterday I have sent the mail annexing therewith the judgments upon which I will be relying upon, Your Lordship.
So it's a short attachment or bulky?
No, it's only 2 judgments. Maybe I will be relying upon, Your Lordship, in that, not a bulky judgment.
3 judgments are there for you. I have 3 judgments. Lord, in item 26, I have a small prayer, my lord.
What happened?
Lord, I am ready with the file. I have read it. I am prepared. Only some issue I wanted to discuss with my clients. I need some clarification with them on some issue, my lord. So if it may come on Monday or any day, subject to your lordship's convenience. My issue is very short, my lord. Facts are also admitted. The facts are admitted that the return was not filed within time.
फोन दो ना, क्या हो रहा है?
Ms. Amrita Sinha, you are addressing.
I'm so sorry. There was some disturbance in my connection, Your Lordship, and I could not. I'm not. Am I able to? Am I audible, Your Lordship? The video and all that are getting paused.
You were audible and you were screaming upon someone, calling for phone.
I'm so sorry, Your Lordship. I'm so sorry. Network issue was there. I apologize, Your Lordship. I really apologize for that.
The difficulty is that the email that you have sent could not get the printout. And
Okay.
Mr. Pati, you also have sent some.
No, my lord, not in this case. In the earlier case, I had sent, my lord.
You want to discuss on some minor issues?
Yes, my lord, some clarification need from, because the facts are not in dispute. There was a delay in filing of the return. He passed an order under section 62. Thereafter, it has been blocked. The electronic delay. Some issue I want to seek their views and clarification.
The delay is not only the concern in this matter, Your Lordship. If permitted, I can put but I won't be objecting to it. But a shorter date may be given because the matter has been
Monday, Tuesday.
I'm not even
It is a
the
frank.
difficulty, Your Lordship. They have blocked my ITC and I am not able to avail it. I am not able to file my returns. If permitted, may I submit the fact of the matter, Your Lordship?
There are two handicaps. One, that your email was received late yesterday and you could not get the printout. The other is that Mr. Pati is asking for a short adjournment.
But it's a Ranchi matter. I can get the instruction within a day or two. If it comes in the next week, by that time I'll discuss it with the officers as well.
Then let it be passed over for the day. Next Thursday it will be there. Monday, etc. We have a bit difficulty. It seems that number of matters are already there.
Not an issue, Your Lordship. Next week will be 24th February.
Tuesday, let it be on Tuesday.
Tuesday, 22nd.
Yes.
Deeply obliged, madam.
Send whatever you have to do by Saturday. Mr. Pati, you also give a short 2-page note as to what
My
is
lord. My lord. I will do it, my lord.
May I just submit one thing, Your Lordship? The facts is not much in this matter. All is the law point involved in the matter is.
That we understand. You say that the order was never served and DRC 07 was.
That is, yes.
Is that when we are not informed beforehand, we go through the file, and then when it is called out, it is adjourned. We have difficulty in accommodating it on any near date, because for the next 2-3 weeks the diary becomes full due to adjournments and case fixation.
Your Lordship.
Any Tuesday.
Much obliged.
Obliged.
Passover.
For revision, Passover case item 60, WPT number 1579 of 2017, Mr. Sanjay Pitova, order.
Please unmute, sir.
case, Lord.
Yes, Mr. Sahai.
Yes, Lord. I am appearing in this case.
Look at the screen. We are not able to see you properly.
Yes, Lord.
Yes. So what is the point involved in this matter?
Yes, my lord, and Section 2 is under challenge, my lord, is the demand notice issued by the District Transport Officer Godda, my lord. If your lordship will...
Who is for the state? No one's name is appearing for the state. Elevate.
My lord, copy has already been served to the estate, your lordship.
No, right from... Oh, the previous council has been elevated.
Right.
We'll ask the Office of Advocate General to... Mr. Sachin, you appear?
Yes, my lord.
On account of elevation of the erstwhile counsel for the state, Mr. Rajesh Kumar, uh, learned AG2, Mr. Sachin Kumar, appears for the state for the first time today and seeks short indulgence. Accordingly, matter is passed over for the day.
Lord, it may come in the physical court, my lord.
हाँ तो physical court में होने का chance है.
हाँ, अब तो चांस है, अब तो हो जाएगा.
The matter appear on 3rd March 2022, so that counsel for the state may be prepared. ठीक है?
My lord,
This is item number, which item, my lord?
My lord, in place of 3rd March, your lordship, my lord, because your lordship, before honorable division bench number 1, the state policy is fixed on 2nd, your lordship, and that may continue on 3rd also, your lordship. It will be on 8th or March, 8th or 9th March.
9th March.
My lord. My lord. Oblige your lordship.
Let the name of Mr. Sachin Kumar Leonard AG to appear in the cause list henceforth for the responding state.
Oblige you.
ये कौन सा सीरियल था? I could not.
16. 157.
My lord.
आप कॉपी वगैरह ले लीजिएगा, फिर अगले डेट को मत बोलिएगा कॉपी नहीं है, ये नहीं. We have earlier.
नहीं हम अभी just now, my lord, just now I will complete whole exercise.
Yes.
From the supplementary policy under the heading for revision, item 1, WPC number 177 of 2021, allowing item number 283.
My lord, supplementary list is called?
Yes, your matter.
I'm sorry, my lord, I couldn't hear it. My lord, yesterday, extract of the book of Justice G.P. Singh and one judgment of Supreme Court in Daiichi, I have sent, my lord. G.P. Singh's book, my lord, on proviso, mainly on proviso.
You have sent some fresh mail yesterday.
Yes, my lord. On proviso, my lord.
Maybe, but I'm not sure. Print out Nikla.
Minutes, I'm very sorry. The mail was since received late night by the senior. It was not an appropriate time, so we sent it early morning today. And I had spoken to the learned court master also. So I think the printouts are ready, I believe.
Yes, it has been given to us now.
My lord.
Yes.
To refresh, my lord, your lordship's memory, what I stated, submitted yesterday.
Yes.
My lord, I was just revolving around section 50 only to make out my case.
And to ascertain the intention of the legislature, my lord, I will like to see something backward and something forward. Because my lord, Supreme Court has repeatedly said that to honor the intention of the legislature, the statute has to be read as a whole, meaning thereby to read what precedes and what succeeds. So on what precedes, I read 49. 39 is also relevant, and what succeed, my lord, is section 51, 52. Yesterday I was trying to read that, my lord, 51 and 52. So to understand the purport of 50, 50, 49, 39, 49, 51, 52 read, to understand what is electronic cash ledger and whether credit in the electronic cash ledger
Yes.
and electronic credit in the electronic credit ledger are at par or not, they mean one and same thing or not to the government. Because my lord, if the proviso says that mere credit in the credit ledger waives the interest because it is as good as tax paid, then I would draw a parallel. I will draw a parallel and say that credit in the cash ledger.
जरा इसको अरेंज कर दीजिएगा, ये सब फंड चीज बहुत यहाँ जमा है। वो पैड सब भी जो है ना, वो आप हटा करके फ्रेश पैड सब 3 तरह का बड़ा छोटा सा। Yes, sorry, Mr. Purni.
My lord, the section 50, subsection 1 imposes
कंपाइलेशन दीजिए, उसी का तो मेन काम है। उसको लेकर रखे रहते हैं। So, to which volume should we go for these sections?
My lord, if you lordship have the book, then we can go through the book, my lord.
The book I have. You were referring from this compilation yesterday. Yes, book we have.
My lord, that compilation I will take your lordship to. My lord, just I am summarizing, my lord.
Yes.
Section 50.
Yes.
As I said yesterday, section 1 is attracted only when there is unpaid tax or there is a default in payment of tax. Then proviso says that mere credit in the credit ledger is sufficient to waive the interest, meaning thereby that without waiting for the date of filing return, because my lord, the date of filing return for both payment from the cash ledger and credit ledger is same, return is same, and if I say that if by filing return the appropriation is done, then my lord, the proviso will become redundant, because proviso does not wait for filing return. Proviso does not wait for filing return to waive the interest. It says mere credit in the credit ledger waives the interest. So the question that arises now, my lord, whether credit in the credit ledger or credit in the cash ledger is sufficient to waive the compensatory interest, or it is the date of debit, on that date only the appropriation will be done, that date will be deemed as the date of payment of tax, and till that the interest will continue. If that be so, the date of debiting credit ledger and cash ledger is the date of filing return. For both it is one and same. The date of appropriation is the date of filing return. If it is so held, the date of filing return for credit ledger, cash ledger is same. If that is so, then the proviso is redundant, because proviso talks about the waiver of an interest on the credit itself. for the debit. If there is a credit in the credit ledger, interest is to debit. So, my lord, under the statute, there is no more two modes for payment of tax, or there is no two mode for payment of filing of return. There is no two date for filing a return from electronic credit ledger and cash ledger. That is why, from the proviso, which throws light, the proviso throws light to the main enactment that it only wants interest for the amount that remains unpaid. The amount that goes into the credit as a credit into the credit ledger, cash ledger credit or credit ledger credit, the amount is to pay to the government. Now compensation will stop. That is the purport of the proviso.
In that case, in a hypothetical illustration, not like yours, the deposit in the cash ledger happens after the due date of payment of tax, whatever is the due date, and return is also filed belatedly. Do you mean to say that the interest over the delayed payment of tax should be computed from the date of deposit, that is, say, 15 days delay from the due date of payment of tax only? Or
yes,
that?
Yes, correct, my lord. My lord, the difficulty here, the thing is that very important thing that is clear to the GST is that I can debit my credit ledger or cash ledger on the date of filing return only. Before that, I cannot debit. If somebody says that you pay and they keep on debiting, and in the return you disclose the date of debit only, that on this date this much amount debited, this date this much amount debited, it is not so as it is in the earlier regime. This is peculiar to the GST that unless you file return, you cannot debit. So you can debit only on the day of filing return. So my proposition is that, my lord, the interest, why I am revolving around the word compensatory, is that once the money goes to the credit, irrespective of the levy of penalty, that penalty may be attracted, late fee may be attracted, all these things may be attracted. But when it comes to interest, the character is only compensatory. And once it goes to the government, credit to the government, the compensation will stop. That is why the proviso says that mere credit to my credit ledger, mere credit, not waiting for the debit. Debit may be after 2 months, debit may be after 6 months. It says no interest. It says no interest. And now, my lord, the proviso has to be read in the context of the main enactment. Main enactment talks about unpaid and default. In my case, there is no unpaid. There is no default. Only comes the issue, as your lordship fell from your lordship, one word of appropriation. What date it will be appropriated. And also, what is the date of filing return, and that date is the date of debit. So the interest will be attracted in context of or in connection with or with respect to the date of debit or the credit.
No,
if it is date of debit,
you see, the argument which is developing on these lines, does it not amount to entering into a domain of legislative policy? Because the legislature had the option to provide that the date of deposit should be treated as the date of the payment of tax. The legislature consciously uses the expression debit from the ledger, and that too on the date of filing of the return. So it has mixed both the events, the filing of the return and the debit, to be a conjoint event for the purposes of payment of tax due as per filing of the return, whatever is due as per the return. Otherwise, the legislature could have given a different line of provision or different expression that no, return you file even belatedly, but if your electronic cash ledger contains a deposit on that date that amounts to payment of tax, or if there is a deposit in the cash ledger, you are also entitled to debit it towards the state exchequer for the purposes of payment of that tax due. It has not chosen that kind of a provision consciously. Parliament has and the state legislature both have that wisdom to choose a particular way. So the Parliament was aware that, or this legislature was aware that there may be situations where there would be a deposit in the cash ledger of the concerned assessee, but that deposit won't be treated as tax paid till it is actually debited.
My lord, there is no debate on that. My point is that what will be the date of payment of tax? The date of payment will be the date of filing return. Right, my lord? But considering the nature of the interest under section 50, 50 is a special provision. 50 is a separate provision. If 50 is a special provision, it creates a separate levy. 50 creates separate levy. 50 is cannot be confused with section 9, which creates a charge of tax. Charge of tax and payment of tax. And my lord, the payment of interest. Interest is not required to be paid on the entire amount. What the proviso says, and rather 51 says, interest is to be paid only on the unpaid amount. Here comes the compensatory nature. When it says interest is to be paid on the unpaid amount, there comes the compensatory nature of the interest. So from the interest, from the language used by the legislature, it can be discerned that the nature of the levy under section 50 is compensatory one. The amount that remained unpaid, only on that portion interest is to be paid. Now, date of payment and date of filing. Date of payment of tax is the date of filing of return. But the money which has already been credited and gone to the government, the legislature doesn't want interest on that. Section 50 says that. It says unpaid amount, only on unpaid amount I want the interest, and which is clear from the proviso. Proviso says mere credit is there, whatever may be the date of filing return. And now coming to my lord, electronic cash ledger and credit ledger. For credit ledger and cash ledger, there is no two different date. There is no two different methodology. There is no two different returns. Same return, same date. But it says that unless the proviso would have been inserted, then things would have been that on the date of filing return, whatever tax you pay, on that you have to pay interest. So the proviso is carving out an exception saying that if there is a credit in the credit ledger, that is as good as payment made to me. You are not required to pay any interest on that. I want compensation for the amount withheld by you. The same analogy will apply to the credit ledger or cash ledger also. Because the legislature does not draw a distinction between cash ledger and credit ledger. Because the proviso has to be read in the context of the main provision. Main provision deals with the cash ledger and credit ledger both. Proviso deals with the credit ledger only. When the main section says unpaid, it is unpaid from the cash ledger, unpaid from the credit ledger. But if it is paid from the cash ledger,
So that is why we gave that illustration yesterday that out of 200, if 50 is to be debited from the cash ledger, then the interest should be computed on the portion of the tax which is debited by the electronic cash ledger and counted for the period of delay for purposes of computing the interest.
my lord, I would put it in a different way. As I was submitting all now to summarize what I have submitted, there cannot be interest for filing delayed return. For delay in filing return, there cannot be any interest. This is a conceptual thing I am saying. There cannot be any. There can be interest only for delayed payment. That is why one says unpaid. So any amount, if proviso would not have been there, what would have happened, my lord? Payment made from the cash ledger or credit ledger. Either of these two, if delayed, interest would have been attracted. No, my lord, then a question would have arose whether mere credit in the credit ledger is as good as payment of tax or not. But payment in credit in the cash ledger, nobody will ask a question because it is already there. I have paid, it is there. When I have paid, it is not no more unpaid. So that question will not arise. Only question that may arise that mere credit in the credit ledger would amount to payment of tax, that the legislature has clarified by inserting the proviso. Why and where from that proviso flew, my lord? The source of the proviso is judgment Supreme Court in the case of Daiichi that I have said, which has followed under judgment in the case of Eicher Motor. Kindly see, my lord, the judgment of the Supreme Court today morning, which is mailed, my lord. The judgment of Supreme Court in the case of Collector of Central Excise versus Daiichi Karkaria Limited. My lord, page last but one page. Sorry, not last but one page, but my lord, page 6. Page 6, my lord.
Which
Page
para?
6, my lord. Para 18, my lord.
18.
After analyzing the morbid scheme, Supreme Court held, it is therefore that in the case of Eicher Motors Limited versus Union of India, this court said that the credit under the morbid scheme was as good as tax paid.
Yes.
So this is the genesis, my lord. In fact, the legislature has recognized this one. Because the question always arose, where mere credit in the credit ledger, it was about the credit ledger only. In cash ledger, I have paid, nobody asked a question. It will not be any more unpaid. Question will only arise, mere credit would amount to payment of tax or not. Here the legislature intervened and clarified. So the main provision covers the credit ledger and the cash ledger both. And proviso says that mere credit is enough. If credit is there, I will assume tax paid to me, don't pay interest. Cash ledger, credit is there, I would assume it tax is paid to me, don't pay interest. Here comes the compensatory nature. Section 50 itself says that the money has come to me, on that don't pay interest. What remains unpaid, pay interest on that. The date of payment, date of debiting for both is one and same. What applies to credit ledger would also apply to cash ledger. The date of filing return, the mode of filing return, date of debiting, the manner of appropriation, what applies to credit would apply to cash ledger also. Now, my lord, I would read the section 51 of the Act, my lord, 51 and 52. To demonstrate what is the character of the credit in the credit ledger, cash ledger, my lord. As I have demonstrated that the credit in the credit ledger is as good as tax paid. Now, what is the character of the credit in the cash ledger, my lord? Kindly see 51. To gather the intention of the legislature, we have to see backward and forward. 39, 49, we have seen, my lord. Kindly see 51. Tax directed source. Notwithstanding anything to the contrary contained in this act, the government may mandate a department or establishment of central government or state government or local authority or government agency or such person or category of persons as may be notified by the government on the recommendation of the council hereinafter in this section referred to as a deductor to deduct tax at the rate of 1% from the payment made or credited to the supplier hereinafter in the section referred to as the deductee of the taxable goods or services or both, where the total value of such supply under a contract exceeds 2,50,000 rupees, provided that no deduction shall be made if the location of the supplier and the place of supply in a state or union territory which is different from the state, as the case may be, union territory of registration of the recipient. Explanation: for the purposes of deduction of tax specified above, the value of supply shall be taken as the amount excluding the central tax, state tax, union territory tax, integrated tax, cess indicated in the invoice. 2. This amount deducted as tax under this section shall be paid to the government by deductor within 10 days after the end of the month in which such deduction is made, in such manner as may prescribe. 3. A certificate of tax deduction at source shall be issued in such form and in such manner as may prescribe. 4 is deleted, my lord. 5. The deductee shall claim credit. My lord, this is very important. The deductee shall claim credit in his electronic cash ledger of the tax deducted and reflected in the return of the deductor furnished under subsection 3 or section 39 in such manner as may be prescribed. So, my lord, the amount getting accumulated in the cash ledger is deduction of tax in the nature of tax. It is collection of tax in advance or by different modes. So the nature of tax lying in the credit ledger and nature of credit lying in the credit ledger, nature of credit lying in the cash ledger is one and same. My lord, thereafter is not necessary. If your lordship permits, I can read that. Two sections are thereafter, my lord. Section 6. If an deductor fails to pay the government the amount deducted as tax under subsection 1, he shall pay interest in accordance with the provisions of section 1 of section 50 in addition to the amount of tax deducted. The determination of amount in default under this section shall be made in the manner specified in section 73 or section 74. The refund to the deductor or deductee, kindly see, my lord, the refund to the deductor or deductee arising on account of excess or erroneous deduction shall be dealt with in accordance with the provisions section 54. Proviso is important, provided that no refund to the deductor shall be granted if the amount deducted has been credited to the electronic cash ledger of the deductee. So it is all going into the same common pool, and that pool is a pool of credit of taxes, and it is a pool maintained by the government, going to the coffers of the government. Then kindly turn, my lord, next page, section 52. Collection of tax at source. Notwithstanding anything contained in this act, every electronic commerce operator, hereinafter in the section referred to as the operator, not being an agent, shall collect an amount calculated at such rate not exceeding 1% as may be notified by the government on the recommendation of the council of the net value of taxable supplies made through it by other suppliers where the consideration in respect to such supplies is to be collected by the operator. Explanation: for the purposes of this subsection, the expression net value of taxable supplies shall mean the aggregate value of taxable supplies of goods or services or both, other than services notified under subsection 5 of section 9 made during any month by all registered persons through the operator reduced by the aggregate value of taxable supplies returned to supplier during the said month. The power to collect the amount specified in subsection 1 shall without prejudice to any other mode of recovery from the operator. 3. The amount collected under subsection 1 shall be paid to the government by the operator within 10 days after the end of the month in which such collection is made in such manner as may be prescribed. 4. Every operator who collects the amount specified in subsection 1 shall furnish a statement electronically containing the details of outward supplies of goods or services or both effected through it, including supplies of goods or services or both returned through it, and the amount collected under subsection 1 during the month in such form and manner as may be prescribed within 10 days after the end of such month, provided that the Commissioner may, for reasons to be recorded in writing by notification, extend the time limit for furnishing the statement for such class or registered persons as may be specified therein, provided further that any extension of time limit notified by the Commissioner of State Tax or the Commissioner of Union Territory Tax shall be deemed to be notified by the Commissioner. Explanation: for the purposes of this subsection, it is hereby declared that the due date for furnishing the said statement for the month of October, November, December 18 shall be the 7th of February 2019. Every operator who collects the amount specified in section 1 shall furnish an annual statement electronically containing the details of outward supplies of goods or services or both effected through it, including supplies of goods or services or both returned through it, and the amount collected under the said subsection during the financial year in such form and manner as may be prescribed after 30 days 31st day of December following the end of such financial year, provided that the Commissioner may, on the recommendation of the Council and for reasons to be recorded in writing by notification, extend the time limit for furnishing the annual statement for such class of registered persons as may be specified therein, provided that any extension of time limit notified the Commissioner of State Tax or the Commissioner of Union Territory Tax shall be deemed to be notified by the Commissioner. If any operator, after furnishing a statement under section 4, discovers any omission or incorrect particulars therein, other than as a result of scrutiny, audit, inspection, or enforcement activity by the tax authorities, such omission or incorrect particulars in the statement to be furnished for the month during which such omission or incorrect particular are notified, subject to payment of interest as specified under in subsection 1 of section 50, provided that no such rectification of any omission or incorrect particulars shall be allowed after the due date for furnishing the statement for the month of September following the end of the financial year or the actual date of furnishing of the relevant annual statement, which was earlier. Then 7 is very important, my lord. The supplier who has supplied the goods or services or both through the operator shall claim credit in his electronic cash ledger the amount collected and reflected in the statement of the operator furnished under subsection 4 in such manner as may be prescribed. So one deals with TDS, tax deducted at source, and one deals with tax collected at source. So these are two methods of collection, and it goes to the common pool. So the character of the pool is the tax, and the character of the pool, cash pool, and the credit pool is one and same. It is as good as tax paid. That is why 51 says unpaid. So money which has already gone to the, suppose my lord, in my case, assuming there is no case of payment by me, I am not making any payment in cash, but I have a contractor or a supplier against whom substantial TDS has been debited and it has gone to the electronic cash ledger. It is the tax deducted at source, and there is substantial balance in my electronic cash ledger. Whether it is still unpaid, that is why, my lord, yesterday I read judgment Tata Chemical. If your lordship will permit me, I will read it again. Now the context is more clear. Third volume, my lord. Third volume. Page 45, my lord.
Para 30.
Para 30, my lord. Page 57. My lord, before I go to that, it will be profitable to read 49, one portion of 49 that I was reading, my lord. Please don't turn the pages.
Yes.
6 I am reading, my lord. 49.6. The balance in the electronic cash ledger or electronic credit ledger after payment of tax, interest, penalty, fee, or any other amount payable under this act, or as the rules made thereunder may be refunded in accordance with provision section 44. The balance in the electronic cash ledger, electronic credit ledger after payment of tax, interest, penalty, fee, or any other amount payable under this act or the rules made thereunder may be refunded in accordance with the provision section 54. So, my lord, the deposits, the credits, the advance payments are in the form of electronic credit ledger, in the form of TDS, in the form of TCS, and deposit in the cash ledger. And after adjusting everything, rest is refundable to me.
So in that case, once again, 49.3. So
49.3, my lord.
Please read 49.3.
The amount available in the electronic cash ledger may be used for making payment towards tax, interest, penalty, fee, or any other amount payable under the provisions of this act or the rules made thereunder in such manner as may be such manner and such subject to such conditions and within such time as may be prescribed. So this amount can be used only for these purposes.
So there is an amount available in the electronic cash ledger, but when you are making a payment towards a tax liability, you have to do an overt act for making that payment. Simply that amount lying in the electronic cash ledger would not amount to a tax paid.
Yes, my lord. There is no confusion on that. I say.
Again, you will come to compensatory in nature.
Yes, my lord. Concept must be clear. We cannot ignore the concept. Concept must be clear. Debiting, if somebody asks me what is the question, what is the date of payment of tax, I would say the date of filing return. On which date the amount is reduced from the credit ledger, cash ledger, I would say the date of filing return. But if somebody will ask me on what amount you will agree to pay interest, then I would say whatever I have paid, on the balance I am agreeing to pay interest. This is as simple as this, my lord.
In your present writ petitions, the voluntary payment that you have made of interest is only for those part of the tax paid which were debited from the electronic cash ledger upon filing of the GSTR 3B, or calculated from a date prior when there was already a deposit in the cash ledger.
My lord, what happens in my case, suppose for April, I had to file my return April 20. I had to file my return by 20th May 20. During April 20 to May 20, whole April 20 to 20th May 20, I, out of supposing my lord 1 lakh, I paid 80,000 rupees in the electronic cash ledger. 20,000 I paid thereafter. I filed my return in June. So for the period of delay in payment of 20,000 rupees, I have agreed and paid the interest. For the period prior to that, 80,000 paid by me prior to 20th May 2020, on that I am disputing my liability. For the rest I have paid. So kindly see my lord now, keeping in mind the compensatory nature, 49, 6, 51 and 52. Kindly see my lord, page 57, para 30, the refund becomes due.
Okay, you are coming to the judgment.
My lord.
Yes.
Para 30, page 57, the refunds become due when tax, my lord, kindly see, this 49.6 it talks about refund. Refund after adjustment of everything. So what is there in the credit? In the credit, TDS is there, TCS is there, my deposit is there, and also the credit in the electronic credit ledger is there. After adjusting all the taxes, that will be refunded to me. It is the same analogy, my lord. The refund becomes due when tax-deducted source, advance tax paid, self-assessment tax paid, and tax paid on regular assessment exceeds the chargeable exceeds the tax chargeable for the year as a result of an order passed in appeal or order other proceedings under the Act. When a refund is of any advance tax, including tax deducted, collected at source. All of these are in the nature of advance tax. Interest payable for the period starting from the first day of assessment year to the date of grant of refund. No interest is, however, payable if the excess payment is less than 10% of the tax determined under section 143(1) or on regular assessment. No interest is payable for the period for which the proceeding resulting in the refund are delayed for the reasons attributable to the HSE, wholly or partly. The rate of interest and entitlement to interest on excess tax are determined by the statutory provisions of the Act. Interest payable payment is a statutory obligation and non-discretionary in nature to the HSE. That in tune with the aforesaid general principle, section 144A. My lord, kindly see the sentence in tune with the aforesaid general principle. Section 244A is drafted and enacted. The language employed in the interest and is the language employed in section 244A of the Act is clear and plain. It grants substantive right of interest and is not procedural. The principles for a grant of interest are the same as under the provision section 244 applicable to assessment before 1/4/1989, albeit with clarity or application as contained in section 244A. Now kindly turn to page, my lord, 60. Para 38, my lord.
Yes.
38. Providing for payment of interest in case of refund of amount paid as tax or deemed tax or advance tax is a method now statutorily adopted by fiscal legislation to ensure that amount paid of the aforesaid amount of tax which has been duly paid is in prescribed time, and provisions in that behalf form part of the recovery machinery provided in the taxing statute. So, my lord, recovery of what? Recovery of the tax in advance. Refund due and payable to the HSE is debt owed and payable by the revenue. The government, there being no express statutory provision for payment of interest on the refund of excess amount tax collected by the revenue, cannot shrug off its apparent obligation to reimburse the debtor lawful monies with the accrued interest for the period of undue retention of such monies. One of kindly see the word undue retention. It is both way. I cannot retain undue, they cannot retain undue. If I retain, I have to pay interest. If they retain, they have to pay interest. So, in the Bharti Airtel, Supreme Court has said that there is a regime change, of course, but it is not a departure. It is not a departure from the old regime. It is only the thing, the old law in new incarnation. So concept is not changed. Concept of interest remains to be compensatory. Whosoever withholds shall be liable to pay interest. This is the common law principle, which is adopted in the fiscal statutes. Because in fiscal statutes, judgments are there, my lord. I will take your lordship to. In India Carbon, Vivesh Sugar, Supreme Court has held that unless there is substantive provision in the Act for creating a charge of interest, it cannot be collected on equitable principles. That is why all taxing statutes are creating provision to compensate itself for the loss of revenue or for delayed in payment of tax. If there is no delay, it cannot be placed into service. So, my lord, that GP Singh may kindly have seen how the proviso throws a light. Okay. उनका बताओ।
As on till date, the this issue which you are raising and the method of computation of interest over unpaid tax, is it a consistent practice followed for the whole of the country, pan India, by the revenue, including the central authorities and the state authorities?
Yes, my lord. Yes. Yes, no debate on that, my lord. Because sincerely, I have worked on that and I am working and I know that only one principle is there. Only one and only one. That is compensatory in character.
No, I'm saying that the computation of interest is being done in the manner as is being done by the revenue in your case throughout pan India, or
The format is GSTN portal. When I went to the department for one case for hearing, and I highlighted before them that see, you are demanding interest for the delay in filing return. They said we are helpless because the computation is done by the GSTN portal in that way. If I am not wrong, my friend will clarify. But this is what was told by the officers of department, that we are not calculating it, system is calculating it. So my submission is that GSTN portal cannot regulate the statute. It is the other way around. The GSTN portal has to fall in line with the statute itself. So pan India must be that, my lord. In all the cases, they might have been doing like this only.
so what you submit would mean that Section 50 proviso should mean computation of interest on only that amount where an SSE is not having any deposit in the electronic cash ledger and is making that payment from the electronic cash ledger by debiting that portion of the amount upon filing of the GST and CP.
My lord.
So that
if I would, my lord, with utter humility, just I would slightly amend a sentence saying that that portion which remains unpaid by me, I will go by the language of statute. That portion which remains unpaid by me, or where I have defaulted in making payment. If I have already paid, there is no question of default, and it doesn't remain unpaid. When it is not unpaid, on that portion I am not required to pay any interest.
the difficulty which we can imagine from the point of revenue would be as to how would they compute the appropriation of taxes if this mechanism is not taken into effect or not given into effect. Will they treat all deposits in the electronic cash ledger also as tax paid without being debited before the actual filing of the return? and treat it as revenue earned by the state.
My lord, 49 says that, 51 says that, 52 says that. So it is bound to be so. Appropriation, my lord, there are two things. One, the provision creating the charge, and then comes the mastery provisions. The filing of return, appropriation, and that kind of thing, these are all mastery provisions. They are to be read in the context or within the limit of the provision creating the charge, not the other way around. It cannot extend the charging provision.
That means you also say that by TDS, by TCS, or other deposits in an electronic cash ledger, the state has already got the tax within the meaning of Article 265. But by charging interest over it again, only when it is being debited, it is doing something which is not permissible under Article 265 per se.
My lord, your lordship is correct. And I would say only the apportionment is deferred. Money is already paid, only the date of apportionment is deferred. They say, okay, I have got your money, but one day we will sit and we will settle it. That does not mean that the money has not gone to him. Money has gone to him. He says that on a particular date we will apportion it. That date is the 20th of the next month. That is the date of apportionment, not the date of payment. Payment is done before.
There might be situations when, say, at the time of filing of a GST 3RB return, with some delay, the complete documents relating to the taxes collected at source or TDS may not be there to be reflected in the GST 3RB return of that date, of the succeeding 20th of that month. In that case, those taxes are being shown in the GSTR 3B or will be shown when the documents are there in the later months?
My lord, the moment the director uploads his return, GSTR 7, the moment it uploads, that amount gets reflected as credit in the cash ledger. And if, my lord, the director does not pay the tax, TDS or TCS within 10 days of the end of the month, then he is liable to pay interest under Section 50. So the character is very clear. What is that amount? Because 50 is for taxes only. 50 is for taxes. And 51, 52 says if you don't pay within 10 days, the next month, you will be liable to pay the same very interest which is made for taxes.
GSTR 3B particulars as a relation and in relation to the documents which are to be disclosed in the return.
My lord, if your lordship would kindly see the concise written notes I have submitted. 3B is enclosed with that. My lordship can have a glimpse of it. 3 concise written notes I have submitted, my lord. Revised written notes. With that, GST 3B is enclosed.
Just, is it that mustard colored?
Mine is not colored.
No. Lutz. It was not in the form of a paper book.
Oh,
it was.
It's not in the form of a paper book.
No, Lutz. Lutz, in 1261 of 2020, it was submitted on 20th of December, Lutz.
Written notes of argument on behalf of the petitioner sent on December 14.
One is written notes, one is revised written notes. With the written note also it is there, my lord.
In the written notes.
Also it is there.
It's also there, GST 3.
It's in landscape format, Lutz.
No, it's in.
Yes, my lord. It is
yes.
TDS का रूल क्या है? लिखता नहीं इसमें।
Yes, Mr. Kurmi, have you got it?
My lord.
Have you got that which we are also, yes, additional
Yes, I am
GST?
having, my lord. I am having.
So kindly take us through that return form just to make us understand on.
My lord, try to see clause 3.1.
3.1.
It is the total tax liability. It deals with total tax liability of a registered person.
Yes.
Tax on outward supply. Person is liable to pay tax in two ways. One, so under section 9.1, which is a tax on charge basis. Whatever you supply, on that you have to pay tax. And 9.3 deals with tax on reverse charge basis. Certain input supplies, input goods or input services, notified goods, notified services, notified by the government, in respect of which the supplier is not to pay the tax, is the recipient to pay tax. It was under the earlier regime also, like the goods transport agencies and operators, on which the recipient was liable to pay. So ultimately, the total tax liability of a registered person is the tax on output supplies plus the tax on reverse charge basis. This plus that is the total tax liability. 3.1 deals with that.
Yes.
Nature of supplies, output supplies, outward taxable supplies, other than zero rated, nil rated, or exempted. Zero rated is, my lord, export.
Yes.
Or interest rate, you can say, my lord. Zero, rather, export. Nil rated, against which no tax rate is specified in the rate notification.
Yes.
Or exempted, in respect of which there is a tax rate is there, but by some notification is exempted. So outward supplies, other than these three, then these, my lord, outward supplies zero rated. IGST को zero rated को बोलते हैं. See, other outward supplies nil rated exempted. Inward supplies liable to reverse charge. Non-GST outward supplies. There are certain items which are not in the GST net. Like petroleum product, I would say at the moment. Petroleum is not in the GST net. Section 9.5 talks about that. It says that GST is leviable on all goods except few. And those are named there.
Yes.
Then, my lord, interested supplies. Supplies made to unregistered persons. Supplied made to composition taxable persons. Composition means, my lord, small dealers who don't pay tax on their invoice basis, but a composition amount determined for the whole year, that they pay. Supplies made to them, they are not entitled for the credit.
Whose turnovers are up to a particular limit. And they,
my lord. Yes, my lord.
They opt for.
Applies to EUIN holders. That is a unique identification number, like diplomatic missions and all that.
Yes.
Then comes the credit part, my lord. This is the tax part. Then comes the credit part. Eligible ITC.
Yes.
ITC available, integrated tax, central tax, state union territory tax, and then the cess. There is a compensation cess also, my lord.
Yes.
ITC reversed on any account. IT reversed maybe because of the apportionment or blocked credit, my lord. there are certain services or goods in respect of which I am manufacturer of particular commodity. Part of my product are nil rated or exempted, and part of my product are taxable. But my input is common. My input is common. So, to the extent of the credit relatable to the exempted or nil rated supplies, the credit is blocked. They cannot take the credit. So, my lord, at the first instance, I take the entire credit, then I reverse the proportional credit. ITC reversed. I am giving you one example of it. There may be myriad situations. I have been giving one of the dominant example of it. Why ITC reversal is there? Net ITC available, A minus B. This ITC is available for utilization, out of which there may be ineligible ITC also. I say, for example, my lord, some construction work. I am not at all entitled to the ITC. If that is included somewhere in the above items, that it is to be included, indicated here. Ineligible ITC has to be indicated separately, which is not in A or B or C. But the department must know what is the ineligible ITC which I have not claimed, or not I am not entitled to claim, for which I am not eligible. That has to also be reflected here. Because, my lord, in the earlier regime, whenever department used to book a case, we used to take a plea always that, see, so much credit I had to sacrifice, I have not taken it. So I have not taken it. Where you have reflected? It is nowhere reflected. I am not entitled, I am not eligible, so I have not taken. So to keep a track of that, how much you are not eligible, there is a column for that also. Exempt, nil and non-GST inward supplies. Interest and late fee. Kindly see, my lord. In the interest, my own interest on my own, I have already paid on integrated tax so much, central tax so much, and state tax so much for this particular period. Similarly, for different periods, I have paid.
Late fee also you have paid.
My lord?
Late fee also you have paid. For central tax.
Yes, 1,000 rupees late fee is also there. Then comes, my lord, payment of tax. Description, my lord. The nature of tax to be paid.
Yes.
Total tax payable. Then, my lord, tax paid through TC. Under that, integrated tax, state duty tax, and cess. How much is paid from the TC? Then tax is paid in cash. Interest paid in cash. Late fee paid in cash. These two last columns are repetition of the earlier columns.
Yes.
This is how I discharge my liability. First, the liability is calculated, output supply, reverse charge. Then came the credit, how much I am entitled. If your lordship would see, my credit utilization must be within the limit I have stated there. Then, can you see, my lord, other than reverse charge, tax paid through ITC, tax paid in cash, then A, other than reverse charge, means on forward charge basis, whatever my liability is there, how I have discharged that. Integrated tax, central tax, means integrated tax paid from integrated tax. Kindly see, my lord. Integrated tax, section 49 clearly says that which credit can be adjusted against which credit. Integrated tax can be used for integrated tax and central tax. So integrated tax against my integrated accumulation of credit, against that I adjusted. And integrated tax I paid in cash, this much amount. For delayed payment, admittedly for delay I made, I paid the interest. The second line, central tax, no liability was there. Sorry, my lord. Central tax I have paid from ITC, this much amount. In cash, this much amount. And interest and late fee.
Yes.
Then state tax, because the rate fixed in the Central Act, assuming, my lord, the rate of tax is 5%, then 2.5 would be central tax and 2.5 will be state tax. And when it comes to IGST, it will be 5% total. And then there will be apportionment among the states by a particular formula. So whatever the amount comes for the central tax, that much amount will come for the state tax also. Same is the cash amount, same is the interest amount and penalty amount.
Yes.
Then comes reverse charge. Reverse charge, integrated tax this much, central tax this much, state tax this much, my lord. That is all GST 3B.
So integrated tax and the reverse charge you have paid from your electronic cash ledger or through cash?
That is cash ledger, in fact, my lord. Cash is, there is no procedure of paying in cash. Cash means cash ledger only. सुरू होगा ना.
Yes, so Mr. Kurmi, do you want to add more to what you have already argued since yesterday or day before yesterday?
My lord, what do you think? Lordship take post lunch?
No, I mean, to the extent necessary, we have understood your line of argument.
My lord.
Otherwise, it's a very interesting field and
Now it is becoming.
it's such an interesting consumption for all of us. State councils must also be benefiting. An overview of many connected provisions also that we may also not be fully conversant with, that also has been explained. But through our queries, you have explained them. But for the limited purpose for which the litigation has been filed, perhaps you have covered most of it. You wanted to cite GP Singh for explaining the purport of the proviso.
Yes, my lord. One or two judgment more I would like to take your lordship to. That is in the comparison already.
So you can just show
But
those.
NTC volume 2 or comparison volume 2.
These are part of your gist which you have.
Yes, in that gist it is there, my lord. I am reading from the volume 2, page 58, India Carbon Limited. India Carbon, that is one of the celebrated judgment of Supreme Court, in which it was held that the provision relating to interest is a substantive provision. It is creation of a charge. Unless there is substantive provision in the Act, the interest cannot be demanded on basis of equitable principles. There has to be one provision. But while holding so, the Supreme Court read its early judgment in JK Synthetics and all other judgments and also held that the charge creation is one and the machinery provisions are one. The machinery provisions are to be read in accord with the charge created. It is not the other way around. I would submit that the filing of return, debiting of the electronic cash ledger or credit ledger, these are all machinery part of it. The charge is created by 50. 50 is on the unpaid amount. So, my lord, if in that light of the submission, I am reading this portion, my lord, of judgment of Supreme Court in the case of India Carbon, page 61, my lord. Para 6. Our attention was invited. Got, my lord?
Just.
Page 61, volume 2, my lord.
Yes. Our attention. Yes.
Our attention was invited to the Constitution Bench judgment in JK Synthetics Limited versus CTO, where it has been held that provisions relating to charging and levying of interest in a statute are provisions of substantive law. The relevant paragraph of the judgment may be extracted. 16. It is well known that when a statute levies a tax, it does so by inserting a charging section by which a liability is created or fixed and then proceeds to provide the machinery to make the liability effective.
Yes.
It therefore provides the machinery for the assessment of the liability already fixed by the charging section and then provide the mode for the recovery and collection of tax, including penal provisions meant to deal with defaulters. Provision is made for charging interest on delayed payment, etc. Ordinarily, the charging section which fixes the liability is strictly construed. But the rule of strict construction is not extended to the masonry provisions which are construed like any other provision, any other statute. The masonry provision must no doubt be so construed as would effectuate the object and purpose of the statute and not defeat the same. Then citations are there, my lord. But it must also be realized that provision by which the authority is empowered to levy and collect interest, even if construed as forming part of the masonry provision, is substantive law for the simple reason that, in absence of the contract or usage, interest can be levied under law and it cannot be recovered by way of damages for wrongful retention of the amount. Our attention was, however, drawn by Mr. So and so in two cases. Even in those cases, or that is CIT versus M. Chandrasekhar and Central Provinces Manganese Ore Company Limited versus CIT, all that the court pointed out was that provision for charging interest was, it seems, introduced in order to compensate for the loss occasioned to the revenue due to delay.
Yes.
So, my lord, the concept of interest is one and only one. This is the judgment of Supreme Court in Constitution Bench. I am reading it again, my lord. All that the court pointed out was that the provision for charging interest was, it seems, introduced in order to compensate for the loss occasioned to the revenue due to delay. But then interest was charged on the strength of a statutory provision. Maybe its objective was to compensate the revenue or delay in payment of tax. But regardless of the reason which impelled the legislature to provide for charging interest, the court must give that meaning to it as it is conveyed by the language used and the purpose to be achieved. Therefore, any provision made in statute for charging or levying interest on delayed payment of tax must be construed as a substantive law and not adjectival law. So, construed and applying the normal rule of interpretation of statute, we find, as pointed out by us earlier and by Justice Bhagwati in Associated Cement Company case, that if the revenue's contention is accepted, it leads to conflict and create certain anomalies which could never have been intended by the legislature. Para 7. The proposition may be derived from the above. Interest can be levied and charged on delayed payment only if the statute that levies and charges the tax makes a substantive provision in this behalf. So from the JK Synthetics, India Carbon also, one thing very clearly comes out, that it is in the nature of a compensatory levy. Then, my lord, if your lordship would permit me some portions of the GP Singh, I would read.
Yes.
My lord, next page, page 215.
For the same volume 2?
No, my lord, separately sent. GP Singh separately sent. Today in the morning.
Yes.
My lord, had the proviso not inserted, tax paid in cash, nobody would have asked interest on that because it's not unpaid. Only question would have arose whether the credit in the credit ledger is payment or not. So to clarify that, the legislature carved out exception by way of proviso only in respect of credit. It was not required for the cash. The normal function of a proviso is to accept something out of the enactment or to qualify something enacted therein, which but for the proviso would be within the purview of the enactment. My lord, should I do it again?
Yes, yes.
Proviso, its real nature, the normal function of proviso is to accept something out of the enactment or to qualify something enacted therein, which but for the proviso would be within the purview of the enactment.
Yes.
As stated by Justice Losh, when one finds a proviso to a section, the natural presumption is that, but for the proviso, the enacting part of the section would have included the subject matter of the proviso. In the words of Lord Macmillan, the proper function of a proviso is to accept and to deal with a case which would otherwise fall within the general language of the main enactment, and its effect is confined to that case. The proviso may, as Lord Macnaghten laid down, be a qualification of the preceding enactment, which is expressed in terms too general to be quite accurate. The general rule has been stated by Justice Hidayatullah in the following words: as a general rule, a proviso is added to enactment to qualify or create an exception to what is in the enactment, and ordinarily, proviso is not interpreted as stating a general rule. And in the words of Justice Kapoor, the proper function of the proviso is that it qualifies the generality of a main enactment by providing an exception and taking out, as it were, from the main enactment a portion which, but for the proviso, would fall within the main enactment. Then, my lord, kindly turn to page my lord, 218.
Yes.
Second para from top, my lord. Ordinarily.
Yes.
Ordinarily, it is foreign to the proper function of proviso to read its
Read it as providing something.
read it as providing something by way of an addendum or dealing with a subject which is foreign to the main enactment. Further, a proviso is not normally construed as nullifying the enactment or as taking away completely a right conferred by the enactment. As a consequence of the aforesaid function of a true proviso, certain rules follow. Then, my lord, next B. Not construed as excluding or adding something by implication, except as to cases dealt by it. A proviso has no repercussion on the interpretation of the enacting provision of the section as to so as to exclude something by implication which is embraced by clear words of the enactment. My lord, I'll pause for a while. The clear word of the enactment, the main enactment is amount paid by cash is paid to me. Proviso is not going to alter that. Proviso is only talking about the credit in the credit ledger. That is why the proviso doesn't say about the cash ledger. Further, as stated by Lord Watson in an oft-quoted passage, if the language of the enacting part of the statute does not contain the provisions which are said to occur in it, you cannot derive these provisions by implication from the proviso. So, when on a fair construction of the principle provision is clear, a proviso cannot expand or limit it. Then, my lord, kindly turn to page 221.
Yes.
C. Construed in relation to section or sections to which it is appended. The language of proviso, even if general, is normally to be construed in relation to subject matter covered by the section to which the proviso is appended. In other words, normally proviso does not travel beyond the provision to which it is a proviso. It is a cardinal rule of interpretation observed by Justice Bhagwati that a proviso to a particular provision of a statute only embraces the field which is covered by the main provision. It carves out an exception to the main provision to which it has been enacted as a proviso and no other. It was therefore held that the proviso appended to Article 286(2) of the Constitution authorizing the President to lift the ban imposed by the same provision was not available to lift the ban imposed by Article 286(1). As observed by Justice CGI Das, it is a fundamental rule of construction that proviso must be construed in relation to the principal matter to which it stands as a proviso. On this principle, it was held that a proviso enabling the government to declare that it would be, then I am skipping that portion, my lord. Then kindly come to, my lord, page 2 to 3.
Yes.
D. Use as guide to construction of enactment. If the enacting provision of a section is not clear, a proviso appended to it may give an indication as to its true meaning. As stated by Lord Herschel, of course, a proviso may be used to guide you in the selection of one or other two possible constructions of the words to be found in the enactment, and show when there is a doubt about its scope, when it may reasonably admit to doubt as to having the scope or that which is the proper view to take of it. As Lord Watson in the same case said, I perfectly admit that there may be and are many cases in which the terms of the intelligible proviso may throw considerable light on the ambiguous import of the statutory words. Madholkar Justice stated the rules thus: there is no doubt that where the main provision is clear, its effect cannot be cut down by the proviso, but where it is not clear, the proviso which cannot be presumed to be surplusage and properly looked into to ascertain the meaning and scope of the main provision.
Yes.
Come to 225. 225, second para.
Yes.
Since the natural presumption is that, but for the proviso, the enacting part of the section would have included the subject matter of the proviso, the enacting parts would be generally given such a construction which would make the exception carved out of the proviso necessary. One can see the word necessary. Carved out of the proviso necessary, and a construction which would make the exception unnecessary and redundant should be avoided. So, my lord, what is included, that is sought to be excluded.
Yes.
What is not included? Only unpaid is included. This is so because the legislative device of exclusion is adopted only to exclude a part from the whole, which but for the exclusion continues to be part of it, and words of exclusion are presumed to have some meaning and are not readily recognized as mere surplusage. That is it, my lord.
Yes.
My lord, if your lordship would take my the revised written notes, just I will the proposition you can lordship see. The propositions yesterday I had sent, day before yesterday, my lord. With that I am concluding, my lord.
A, B, C.
A, B, C, my lord, the A that is there, B circular, which says that directly you can recover, that portion is challenged. I say that when it is disputed, so much notice is required to be issued. That I have argued. C, I have argued, my lord. D, substitution of GST 3B with effect from 1/7/2017 by substituted rule 61(5) does not make the levy of interest retrospective. Then, my lord, E, without prescription of the manner of calculation of interest under section 52 of the JGC Act by rules framed under section 287, demand of interest is illegal in absence of computation provision, and the levy of interest cannot be enforced. There is no substantive provision under the IGST Act 2017, hence by reference to reference to section 51 of the IGST Act, no interest can be demanded. After issuing first DRC 01A dated so and so, the respondent number 4 had become functus officio, hence issuance of impugned DRC 01A 5/11/2011-21 again for the period April 19 to December 19 without jurisdiction. So in one particular case, after passing the order, they have gone back and again issued DRC 01A. So that I am challenging. And my lord, as far as this one is concerned, F is concerned, I have said yesterday that there are judgment of the Supreme Court Constitutional Bench in the Khemka, and also there is another judgment Supreme Court which says that the word mutatis mutandis is used in the IGST Act. So that mutatis mutandis word will bring with it substantive provision of the CGST Act also. So I will not harp much on that, my lord. Then, without prescription of the manner, 52 says how interest is to be calculated. And the manner is to prescribed by the rules. The rules are not prescribed. So when the necessary provision fails, computation provision fails, the charge will also fail. That is settled proposition. Judgment, my lord, I have already given the compilation. Gist of notes also there. 3-4 judgments are there where the court or Supreme Court is held. When the necessary provision fails or the computation provision fails, the charge will also fail. Charge cannot be enforced. And coming to the D, my lord, what has happened? Initially, GSTF 3, GSTF 3 is returned on 39. As per 3, I have to, if there is a failure, I have to pay the interest. Then later on, 3B was substituted in lieu of 3. Thereafter, the word lieu of was deleted, meaning thereby that 3B is not written at par with 3. Section 50 levies interest only in respect of 3, not 3B. Then thereafter, there was a respective amendment in October 2020 which substituted 3 by 3B with respective effect from 1/7/2017. So initially, only 3 was there. Interest was in on failure to file 3 or non-payment of tax as per 3. Then there was 3B came, and with that the word in lieu came. In lieu of 3, 3B was introduced. Later on in the rules, in lieu was deleted, meaning thereby that it is not a return in lieu of 3. I am liable to pay interest only in respect of 3, not 3B. Then thereafter, in October 2020, 61(5) was substituted and it was declared that 3B return is a return in lieu of 3 from 1/7/2017. So my submission is that by virtue of that amendment, retrospective amendment, no doubt 3B return has become 3 return now. But it is one thing to say that 3B return is a 3 return now from 1/7/2017, but it is another thing to say that the interest which was on 3 is also created with respective effect.
Understood.
That contention I have taken in my written notes also, my lord, and is also in the petition. And the relevant portions I have referred to. So, my lord, I will not must take your lordship time. I know that, my lord, I have tired your lordship.
No.
I am concluding, my lord.
So, Mr. Sachin and Mr. Yadav, in between you have made your submissions on issues and your counter affidavit is there. You wish to elaborate on that?
Yes, my lord. Some more points we would like to, my lord, argue.
Like?
My lord, two judgments, my lord, I have sent regarding the scope of, my lord, the proviso, my lord. And if your lordship want, my lord, we can refer those judgments right now, my lord.
What more points do you intend to?
My lord, whether your lordship is proposing, my lord, to conclude this matter today, hearing.
Yes, we have heard it enough. And
my lord.
Let's see, we are not disclosing our mind, but we will keep it under orders on some day, and then on that day we will dictate the order in court to pronounce it.
My lord, can you lordship, my lord, grant us one indulgence, my lord? On Monday, I will take 10 minutes, my lord, if your lordship permit.
So, no, why do you want it to spill it over to the other day? Because today we are free now also. So, if you can continue,
my understanding is just now concluded, my lord. So, if I get a chance, my lord, to revisit the entire argument, and my lord, we will take hardly 10 minutes, because important issues are involved, my lord, we don't want to, my lord, do it in hurry. So ultimately, your lordship has to decide, my lord. So only 10 minutes, 15 minutes, my lord, we will take. If possible, on Monday, your lordship grant us, my lord.
No, that would be difficult. In continuity,
Yeah, this will be the first matter, my lord, on this issue. So we also we would like, my lord, to give proper assistance. So though we have raised argued, my lord, in part yesterday, but that will be in the interest of justice, my lord, that we should get some. Only on Monday, my lord, 10, 15 minutes, your lordship can spare for us, my lord.
what you can do, in fact, both Mr. Kurmi and you, both the state councils can do, is to give the written notes and additional gist have again become multiple from your office, Mr. Kurmi.
My lord.
So you can consolidate it in, say, in one written notes or written gist of 4-5 pages, additional gist, whatever it is, that contains the entire gist of your argument and bare facts which you want to address.
My lord, in one written notes, judgments, relevant judgments and relevant portions, I will cite it, and that I will forward to your lordship.
No, and the propositions also, which you were.
Yes, proposition also.
So it has become too spread out, one after the other, it has been coming. So in one short 5, 7, 10 pages notes, everything can be concised. Similarly, the State Council can also give it to us. You can give it by Saturday because we do not want to keep it for pending for very long. It should be fresh in our minds. We will be working on it in the weekend also. So if tomorrow, well and good. If not tomorrow possible, then by Saturday, you can send it to us.
By Saturday, my lord, we will do it.
But so the state councils can also give it by Saturday.
My lord.
My lord, only one provision I just wanted to show to your lordship, my lord.
Yes.
If your lordship permits, my lord.
Yes, yes.
My lord, I wanted to refer, my lord, to Rule 61, my lord, which is the procedure for filing, my lord, GSTR 3B, my lord.
Yes.
Rule 61, my lord. 61.1, my lord, that says, my lord, may I read, my lord? It's a very short provision, my lord, I will be referring, my lord.
Yes, yes.
Every registered person other than person referred to in section 14 of the IGST Act or input service distributor or a non-resident taxable person or person paying tax under 10 or sections 50, 51 or as the case may be under section 52 shall furnish a return in form GSTR 3B electronically through the common portal either directly or through a facilitation center so and so is specified under, and the prescribed date is there, my lord. Under sub rule 1 subsection 1 of section 39 for each month, my lord, two types of return is to be furnished, my lord. Subsection 1 of section 39 for each month or part thereof on or before the 20th day of the month succeeding such month. So this is the time limit that on for each month, the next succeeding month, the return has to be furnished by 20th, my lord. Now, your lordship may kindly, I am referring to 2, my lord, 61.2, my lord. Every registered person required to furnish return under sub rule 1 shall, its word is shall, subject to the provisions of section 49. My lord, section 49 is relating to, my lord, cash credit ledger. Discharge his liability towards tax, interest, penalty, fee, or any other amount payable under the Act or the provisions of this chapter by debiting the electronic credit cash ledger or electronic credit ledger, and include the details in the return in form GSTR 3B. So the liability to discharge the tax, so the discharging of tax liability, the time limit is, my lord, 20th, my lord. And if somebody, my lord, furnishes his deposits the amount, my lord, by furnishing GSTR 3B belatedly by 1 month or 2 months, interest will accrue only on that part of the delayed payment which has been paid through electronic cash ledger, my lord. And the proviso has clarified that the interest is levied on the on the net taxable amount, my lord, which is paid through cash credit ledger, my lord, and not through, my lord, credit ledger, my lord. That is clear, my lord.
That is the substantive provision itself, section 39(7).
Yes, my lord. 39(7) is the substantive provision, my lord.
The rule is only in furtherance of that.
My lord. And one more thing, my lord, I just wanted to clarify, my lord. Rule 87, my lord, that also is relevant, my lord. That further elaborates section 49, my lord.
Yes.
The electronic cash ledger under subsection 1 of section 49 shall be maintained in form GST PMT 05 for each person liable to pay tax, interest, penalty, late fee, or any other amount on the common portal for crediting the amount deposited. The word is crediting. So until unless the amount is credited towards discharging the tax, my lord, and the interest, my lord, he does not get, my lord, he does not get the discharge from, my lord, the liability. And debiting the payment therefrom towards tax, interest, penalty, fee, and any other amount. Any person or person on this behalf shall generate a challan in form GST PMT 06 on the common portal and enter the details of the amount to be deposited by him towards tax, interest, penalty, fees, or any other amount, man. Proviso is there, my lord. So and so, my lord. Now, my lord. My lord, then rule 5, my lord, sub rule 5 of this rule 87, my lord, where the payment is made by NFT or RTGS mode from any bank, the mandate form shall be generated along with the challan on the common portal, and the same shall be submitted to the bank from where the payment is to be made, provided that the mandate form shall be valid for a period of 15 days so and so. On successful credit of the amount to the concerned government account maintained in the authorized bank, a challan identification number shall be generated by the collecting bank, and the same shall be indicated in the challan.
Right.
Well, so on receipt of the challan identification number from the collecting bank, the said amount shall be credited to the electronic cash ledger of the person on whose behalf the deposit has been made, and the common portal shall make available a receipt to this effect. Where a bank account of the person concerned or the person making the deposit in this behalf is debited, but no challan identification is number is generated but not communicated to the common portal, the said person may represent electronic in so and so through the common portal to the bank or electronic gateway through which the deposit was. So if there, even if there is discrepancy, my lord, the provision is there, my lord, how the amount is to be credited, my lord, into the electronic cash ledger, and how it has to be credited towards uh, payment of tax, interest, and penalty, etc. my lord. So the contention of my learned friend that once the amount is lying in the electronic cash ledger, there will be a presumption that he has discharged the tax liability, my lord. That does not stands, my lord, in law, my lord. My lord,
Yes.
we will submit a short synopsis also, my lord, of our interviews.
Judgments, my lord, two judgments, my lord, today only, my lord, I had said, if your lordship has got copy of this said judgments, my lord, 2004 volume 1 SCC, my lord, 574, Haryana State Cooperative Land Development Bank case, my lord.
2004, 1 SEC.
1 SCC, my lord, 574. On the scope of, my lord, the proviso. My learned friend Mr. Kurmi has already referred, my lord, from the GPC, my lord.
41 SCC page
574.
574. Paragraph 9, my lord, at page number 578.
Okay. Yes.
Before coming to the, my lord, yes, I will take 5 minutes of your lordship, my lord.
Paragraph 9. The normal function of a proviso.
Normal function of a proviso is to accept something out of the enactment or to qualify something enacted therein, which but for the proviso would be within the purview of the enactment. So, my lord, the proviso, when one next page, my lord, as was stated in Mullis versus Treasurer of Survey, Surrey, so, my lord, when one finds a proviso to a section, the natural presumption is that, but for the proviso, the enacting part of the section would have included the subject matter of the proviso. The proper function of a provision is to accept and to deal with a case which would otherwise fall within the general language of the main enactment, and its effect is confined to that case. Now, what has happened here, my lord? Earlier, my lord, section 50 is there, my lord, since its inception. So, interest was being charged on the gross tax liability. My lord, just to clarify that the interest will be charged on the net tax liability, which is discharged by debiting the cash ledger. My lord, this provision was inserted. So, it is limiting, my lord, the scope of virtually section 50. It is limiting, and it is now by virtue of this provision, my lord, read with the main substantive provision of section 50. Now the interest can be charged only, my lord, on the amount of tax paid by debiting the cash, my lord, ledger. Now, your lordship may kindly take trouble, my lord, to see section 50 once again, my lord. Now, my learned friend, my lord, has argued much, my lord, and several points have been raised. The issue here is, my lord, that what is the scope of section 50?
Yes.
My lord. And while my lord, charging interest or claiming interest, what has to be seen by the department? That from the wordings of section 50, my lord, that is clear. Interest on delayed payment of tax. Every person who is liable to pay tax in accordance with the provisions of this act or the rules made thereunder, but fails to pay the tax or any part thereof to the government within the period prescribed, shall for the period for which the tax or any part thereof remains unpaid, pay on his own interest at such rate not exceeding 18% as may be notified by the government on the recommendations of the council. Now, my lord, what has to be seen? While my lord claiming interest, only one thing, my lord, that tax was belatedly paid. Now, by virtue of the provision, my lord, it is clear that the tax cannot be said to be paid unless and until, my lord, the amount is apportioned from the electronic cash ledger. So, it cannot be said to be paid unless and until the amount is debited, my lord, from the electronic cash ledger. And this is a clear provision. My lord, the provision is not under challenge here. So we have to go by the provision of the my lord, Act, and that by virtue of the provision, the interest is, my lord, payable by the my lord, SSC on the amount of tax paid by debiting the cash ledger, my lord. that is the scope of section 50. My lord, by virtue of interpreting, virtually my learned friend is trying to enlarge the scope of section 50, my lord. That is not permissible. The whole purpose of, my lord, the act will be frustrated, my lord, if these objections which are being raised by the petitioner, my lord, is virtually that is beyond the scope of section 50. So these are not fit to be entertained by the honorable court. Secondly, my lord, so far, my lord, the amendments which have been carried out in the proviso, one judgment I had sent, my lord, regarding yesterday, it came from your lordship, my lord, and really we are obliged, my lord. Levied, two words are there, my lord. Earlier it was levied, now it is payable.
Yes.
So that amended provision, my lord, earlier, my lord, the provision was inserted, my lord, in 2019, provided that the interest on tax payable in respect of supplies made during a tax period and declared in the return for the said period furnished after the due date in accordance with the provisions of section 39, except where such return is furnished after commencement of any proceedings under section 73 so and so, shall be levied. Now, my lord, in place of levied, the word payable has come in. So I have sent one judgment, my lord, of the Honorable Karnataka High Court, my lord, old judgment, but the word levied has been, my lord, considered, and the meaning of the levied has been explained. Secondly, my lord, so far the word payable is concerned. That also, my lord, carries some significance here. My lord, I am coming to that. That is, my lord, AIR 1965, Mysore 170. Page number, my lord, 190.
Yes.
Page 190, my lord, the on left hand side, my lord, the last paragraph, an argument was advanced.
Yes, yes.
My lord, an argument was advanced that while the main subsection 1 of section 4 states that there shall be charged, levied and paid tax, proviso 1 has omitted the word charge and paid, but only used the word levied. I am unable to see any substance in this argument. The charging section is to be interpreted in accordance with the rules of interpretation enunciated above. In my opinion, the word charged in the opening words of subsection 1 of section 4 was redundant, and the word levied was sufficient to convey the intention of the legislature. The word levy, as applied to taxation, has no doubt been given a variety of meanings. It is sometimes used in an administrative sense as referring to the mere ministerial or executive acts of ascertaining and entering the taxes on the tax book and collecting them, but in its proper sense, as applied to the determination of the amount or rate to be charged, it is the formal and official action of the legislative body invested with the power of taxation, whereby it determines and declares that a tax of a certain amount or a certain percentage on value shall be imposed on persons and properties subject thereto. When next period on the same page, next paragraph, when the word levy or levied is used in the charging section, whether in the main section or its proviso, the only possible meaning to be given is that it is the determination of the amount of rate charged by the legislature invested with the power of taxation. If the word levy or levied had been found in a section or rule dealing with administrative or ministerial acts, it might be possible to hold that it was used in the sense of computation of tax. The drafting of section 4, as my learned brother has rightly observed, is not happy, but the intention of the legislature has been clearly indicated in that section and to be seen from the proviso 1 or so and so. Now, my lord, so far the word payable is concerned. The dictionary meaning of, my lord, I try to search some judgment, my lord. I will try, my lord, and see it if possible. Otherwise, my lord, the dictionary meaning of the word, my lord, this payable. It says, my lord, what is to be paid under any liability? Liable to be paid. The word payable is a descriptive word meaning capable of being paid, suitable to be paid, admitting or demanding payment, justly due, legally enforceable. So, by virtue of section 50, my lord, the word payable has been used, my lord, in the proviso. So now, my lord, and other words which have been used that also carry significance, my lord, on, my lord, every person who is liable to pay tax in accordance with the provisions, but fails to pay the tax, so and so. So on its own, my lord, and the word payable. These two words will not carry much significance, and it should have been an act of the petitioner himself. What has to be seen, my lord? Delay is there in payment of tax. Then, my lord, automatically the interest becomes payable by the petitioner. And only thing, my lord, the computation part. Substantive provision is there. This is a mandatory provision. My lord, I have seen the judgments of the Chennai High Court, my lord, and two judgments, my lord, I have seen that say that this is a substantive provision and a mandatory provision. So it has to be, my lord, followed, adhered to, my lord, in its my lord, toto. There is no question of any deviation from this substantive provision. My lord, other points which my learned friend has seen, my lord, are good regarding, my lord, delay in filing of, my lord, return. Delay in filing of return, my lord, always with under any my lord law, whether it is income tax or any other law, my lord, only late fine is payable. Even under the Income Tax Act, my lord, if there is a delay in filing of the return, definitely, my lord, only late fine. But so far, late fee. But so far, my lord, delay in payment of tax is concerned, interest is automatically payable. My lord, and cash, my lord, ledger is nothing like, my lord, we are my lord, having the savings bank account in the same bank and the FD. We cannot claim that since money is lying in my savings bank account, so I'm entitled to get, my lord, the interest like fixed deposits. So that will not extend, my lord. So situation is different unless, my lord, the amount is debited. It comes to the coffer of the government by as a tax. The government cannot use it. So, my lord, the interest is payable on that amount.
There is one catch in what you cited as an illustration that even in our savings bank or FD, every year when we file our returns, you see that the bank gives a statement of the TDS deducted, that is at source.
Yes, my lord.
The petitioners contend that that TDS once deducted becomes a revenue to the state exchequer.
Yes,
And that is what lies in the electronic cash ledger. So it is not within my control. TDS, TCS, etc. goes into the coffers of the revenue. Why should it not be treated as tax paid if it is due on a date and there is a deposit in the cash ledger? Why should then it not be treated? Simply because the machinery provision of filing of GSTR 3B says that only on filing you can debit it. That should not mean to say that even though tax has been collected and lying in electronic cash ledger, it should not be treated as tax paid on that due date. That is what is there.
Definitely, my lord. I am obliged, my lord. But here question is, my lord, if your lordship will see the provision of section 54 as a whole, my lord, the SSC has a right to, my lord, take refund of the amount deposited in the, my lord, the cash ledger. Reason being, my lord, because the amount, if the amount is not apportioned against the tax, he has a right to claim, my lord, refund. Once the amount is, my lord, apportioned against the, my lord, tax, it cannot, claim cannot be made on account of refund, my lord. So that is the basic difference. That, my lord, tax deducted at source, my lord, maybe, my lord, there may be a situation that tax is deducted, but there was no tax liability. So one can claim refund. So unless that is apportioned against the, my lord, the tax liability, the government cannot treat that amount as, my lord, its money, and it cannot be used for any purpose. It has to be, my lord, kept there. It is like a suspense account.
Suspense.
So that is
It is like a suspense account, my lord. We cannot. It has not come to the coffer of the government. And, my lord, it is like an e-wallet. Money lying there, the person can take refund, use for its own purpose. The person can use it for discharging his liability by below debiting the account from his e-wallet and pay the tax. So unless this is exercised, and your lordship will appreciate, 20 days time is there, my lord, for filing of return. And the facts of this case is, my lord, otherwise also peculiar. I have sent, my lord, the cash ledger of the petitioner. Copy I have forwarded to my learned friend also. Your lordship will see, my lord, that to some extent, in my humble submission, the argument is, my lord, only for academic purpose. Because, my lord, of number of dates, my lord, the amount lying in the account of the petitioner is nil. There was no cash, my lord, if your lordship may see, my lord, the cash ledger.
No, that document,
delay is, my lord, admitted in that is there, my lord. Payment has been made, that is also admitted. So it is only a matter of, my lord, computation. If there was any dispute with regard to computation, they could have raised it, my lord. And
therefore, again, you are coming down to their own point. That if only they get an opportunity to object to the kind of computation where you might be right or they might be right or someone might be wrong also.
my lord.
Till then, how will the unilateral determination of the interest based upon a mathematical formula, computation, etc., treated to be absolutely beyond reproach or beyond any correction?
My lord.
It's a reverse consequences. Suppose your computation creates an amount which is not as per what it is due from him, then it is a unduly retained amount with the state. So you cannot extract it, you cannot retain it. So to that extent only, the adverse consequences which flows from that act needs a opportunity to
And even the Act says,
explain.
even the Act said 73.5, 73.3.
My lord, my lord, so far, the query of your lordship is concerned, my lord, if I have correctly, my lord, the stand which we are taking, my lord, that 73 provision is not applicable, 73, 74 is not applicable. So far, my lord, computation part is concerned, we have provided, my lord, the principle of natural justice has been followed, opportunity has been granted, so it is limited only to the computation part. The delay has to be seen, my lord, in debiting the amount multiplied by, my lord, the rate of interest. It is only a arithmetical, clerical work, nothing else. So enough opportunity has been granted, my lord, for this purpose. So far, my lord, my lord.
This line of argument doesn't cut ice because your own provisions, Rule 142, etc., Section 73, 5, etc., all those, they are laid down by the legislature. And
Then your lordship will consider, my lord, we have already argued, my lord, that proviso was not earlier there while Mahadev construction was decided, and Section 50, ambit of Section 50, my lord, it is being enlarged. That, my lord, in my humble submission, is, my lord, we are reading something in Section 50 which the legislature has not provided. This was not the intention of the legislature, my lord, that even for the purpose of, my lord, calculation of interest, a full-fledged, my lord, proceedings should be initiated and, my lord, the matter be lingered. Now what is happening, my lord? Now, even while filing the return, the SSCs are required to, my lord, deposit the tax at the same time. Otherwise, the return will not be accepted, my lord. So, my lord, enough opportunity has been granted only because DRC 01A was issued. So, my lord, it will not create a right in favor of the SSC. And, my lord, principle of natural justice has been followed. My lord, the last point which my learned friend was raising, my lord, with regard to non-framing of rule, my lord. So, I will, my lord, send the judgment. My lord, 2009, volume 8 SCC. I will not send it, my lord. I will send it, my lord, with my compilation. 2009, volume 8 SCC 492. On the similar issue, my lord, the action taken by the authority without framing rule will not render it unworkable. If otherwise, my lord, the substantive provision of the Act is clear on this point.
Yes, there are line of decisions on that also.
My lord. So Mahadev construction, my lord, I try to distinguish, my lord, actually we try to distinguish, my lord. on the point that provision was not there, 75-12 was not considered in the earlier judgment. These points your lordship will take into consideration. My lord, rest of point, my lord, if any we have not addressed, my lord, we will send it by way of, my lord, the written argument, my lord.
My lord, just 1 minute I will take, my lord. The first point of issuance of so-called notice is concerned, I am directly covered by mother construction. So this court has already taken a view. And my lord, coming to 50 subsection 2, just I am reading, my lord, 50 subsection 2, the interest under subsection 1 shall be calculated in such manner as may be prescribed under section 287 by rules, as may be prescribed from the day succeeding the day on which the tax was due to be paid. So for that, there are two lines of arguments. One, that in one case, under the state sales tax law, the entire machinery was available. But in the Central CST Act, machinery was not there, substantive provision was there. The court held, by virtue of referential legislation, the section 9(2), the machinery can be adopted from there. And it cannot be said that interest cannot be calculated. So that way it was also held. Now in this case, what's happening? CGST Act and JGST Act is substantive provision. CGST Act and JGST Act is substantive provision. In the substantive provision itself, there is no provision. IGST Act is borrowing from the JGST Act or CGST Act. One may say that CGST Act and JGST Act is continuing provision. IGST Act may say that no, it is there, so it is sufficient. My point is that even under the CGST Act and the JGST Act, there is no mechanism provided. And Supreme Court 4 judgments I have referred, RB Falcon, BC Srinivas, in which it is held that when the machinery provision fails, the charge will fail. When the compulsory provision fails, the charge will fail. This is one situation, that is our case. And a situation where the referential legislation by way of referring statute, the other statute is having machinery, this referring statute having no machinery. So machinery form can be taken from that statute. That is different thing. In our case, in none of the three statutes, nor in the CGST, nor in the JGST, nor in the IGST, there is any compulsory mechanism. So this is a case where there is no compulsory mechanism at all.
Very well. Please give the citations of those two judgments which you had said, that Khimka and the one which has.
My lord, that is on computation, my lord.
On that proposition, proposition F. Yesterday also you said that.
Yes, my lord. Proposition F. Judgments are, my lord. Chemka and company agencies in the bracket, my lord, agencies, private limited.
Yes.
Versus State of Maharashtra, 1975.
Yes.
35. STC.
Okay.
STC 571. And my lord, CCE.
STC. Page number, STC?
571, my lord.
571.
Supreme Court, SC.
SC, yes.
And the other one is CCE.
CCE.
Versus Orient Fabrics Private Limited. 2004.
Yes.
One SCC. 597. And in this two judgment, my lord, it is held that unless there is substantive provision, it cannot be levied. But there is judgment Supreme Court which says the use of the word mutatis mutandis in the referring statute is sufficient to invoke the substantive provision of the referred statute. That is, my lord, Indian Oil Corporation Limited.
Yes.
versus State of UP. 2019, 16 SCC,
Yes.
482.
Yes.
Lord Khemka is a constitutional judgment,
Mm-hmm.
and this Wooden Fabrics is division bench judgment,
Mm.
and my lord, this Indian Oil Corporation is a division bench judgment. I'm sorry, my lord, the Wooden Fabrics is a larger bench.
Okay.
Khemka is constitutional bench, Wooden Fabrics is larger bench, and the Indian Oil, which runs against me, it is division bench. And my lord, the judgment I said that unless there is competition mechanism, the charge will fail. Judgments are, my lord, just kindly note down judgment, my lord. CIT versus BC Srinivasa Setti. B.C. Srinivasa Setti, 1981,
Yes.
2 SCC,
Yes.
460,
Yes.
R and B Falcon,
Yes.
bracket capital A,
Mm.
Pty dot limited versus CIT, 2008, 12 SCC,
Yes.
466. Then, my lord, CCE versus,
That would suffice.
my lord, CCE versus Larsen and Toubro Limited, 2015, 39 STR,
Yes.
913 SC. 2015, 39 STR, 913 SC. That is on that, my lord. Where there is no competition mechanism at all.
Yes.
One thing to say that there is a competition mechanism somewhere available in the statute, in some referred statute or referring statute, and it is one another thing to say that there is no mechanism at all. Our case is that there is no mechanism in CGST, KGST, or IGST. These citizens are on that line.
And rules have not been framed.
Rules have not been framed at.
बैठ गया लगता है क्या कुछ
Please send your appearance. So, as per the understanding, by Saturday latest, please send your
My lord.
very concise.
Very concise, my lord.
Arguments concluded. Post the case for orders. No much. मतलब भी 16 ही। 7th March.
But hopefully by then we would be physical.
Physical most likely for next week in a limited few days.
Yes.
Then that we can please. Very well. Thank you.
Obliged, my lord. Deeply obliged.